Hello, all the beasties. Welcome to the lair. How's everybody doing tonight? Hope everybody's good. So, we're going to cover some legal stupid because you would think a psychic, an amazing TikTok psychic, would know how a court case would end up and and maybe use it to their advantage. No. This one, I can't even say she woke up and chose violence because that's not it. It's more like she woke up and chose brain dead. So, for those of you who are not aware, we're going to quickly run through the original complaint. We're going to talk about the issue that this psychic has, and then we're gonna read this psychic's absolutely monumental, should stand the test of time for all ages, immaculate countersuit. What? Yeah, this is gonna go well. So, before we do, everybody introduce yourself. Croc, Iris, Patty, introduce yourselves. Plug whatever you would like.
Yeah, I am the Lord of the Crocker Squirrels. I'm coming off of a Kerbal Space Program 2 live stream earlier today. You should all go watch it because that rocket was just way too much. Way too much. And it says something about how easy it is for me to build those things at this point. They changed things quite a lot. All right, so don't forget to do all of the YouTubey things. So like, the comment, the subscribe if you have not. Share with everybody, including the Twitterverse. Maybe they'll like it. Okay. Iris, you want to go next?
Hey y'all, I'm gonna be muted for a second because my dog wants to go kill somebody, but I'm a paralegal for almost 20 years and I'm just here for the laughs.
Hey everyone, you guys know me. I'm Patty. I am part of the Snark Patrol over for Lord Clocko Swirl and one of Loki's many moderators. I think she considers me part of the OG squad. In addition to that, I've been working in the finance industry for over 20 years, and before that, I spent 6 years attached to a police department as an animal control officer. So I have lots and lots of law experience behind me that I deal with. And I'm also here just to make sure we have fun, because fun is good.
We're gonna have fun. Hey Andrea, hey Claude. Hold on. Andrea, Claude, Sin, Intellectual, Will Call. Hello. Oh, Kel Marie. Guys, buckle in. This is going to be. Hello, Covert Design. Saying hi for the first time. Everybody say hi to Covert. First time person's saying hi to all of us. Hi. Welcome. Come have fun. Okay. So let's start with the basic complaint, just so we have the foundation of this. So, the very short version, the Idaho tragedy happens, and the TikTok psychic, in all of her psychic wisdom, decides to announce that the guilty party is a professor, and not even from the same school. And when she's told no, that's not possible, and to shove it, she doubles down. So finally, the professor files a defamation suit. And we're going to cover that. But then this psychic, she decides to blaze her own path. She is going to go down in history. So, hey, Golden. So
he
let's
is tripping
go.
down the trail of
no.
My guess is from what little Loki has said about this, I'm guessing she's just tripping.
No, I don't even think that. I think she is like, you know, when you see in the old movies, the person standing on the railroad cart where you have to do like the up and down thing.
Oh,
She's
geez.
doing that like head first, going towards a bullet train at this point.
Ooh. No. You do not wish to collide with the Shinkansen. That never ends well.
Yeah, this is gonna be this is
Hi,
this is
Golden
going to
Girl.
be funny.
Hey, Andrea.
This is gonna be fun. Okay, so let's start with
I have a
this.
fair
And
question in the chat beforehand.
Mayor Wrench, you will see her skill level. Trust me, she gives you her credentials. She's gonna tell you how she knows she's the best thing since sliced bread. Ah, so here we go, guys. This is
She said
filed.
she was a psychic. She didn't say she was a good psychic.
Oh, even that's a stretch.
Well, she's
this
going to
has
have
been
to win the
filed-
lottery to pay this defamation off.
Oh, nope. I don't think it's going to help when we get to her thing. So this is filed in the United States District Court for the District of Idaho. Rebecca Schofield, also known as a professor. Ashley Gilliard, which is our TikTok psychic. So let's go. Introduction. In November of 2022, 4 students at the University of Idaho were murdered at a home near the campus. The tragedy has garnered attention and inflicted great sorrow throughout the university, the state, and the country. Defendant Ashley Gilliard, a purported internet sleuth, decided to use the community's pain for her online self-promotion. She has posted many videos on TikTok falsely stating plaintiff Rebecca Schofield, a professor at the university, participated in the murders because she was romantically involved with one of the victims. Gilliard's statements are false. Professor Schofield did not participate in the murders, and she never met any of the victims, let alone entered a romantic relationship with them. Gilliard's videos have been viewed millions of times, amplifying her online persona at the expense of Professor Schofield's reputation. Professor Schofield now sues Gilliard for defamation. Where have we heard this? Plaintiff, she's an individual residing in Idaho. She's an associate professor and the chair of the history department at the University of Idaho in Moscow. Defendant Ashley Gilliard is an individual residing in Texas. Iris, she's one of yours. She is
Hey,
a TikTok.
I'm not claiming her.
I'm sorry,
I'm just
Iris.
saying.
I don't think she's
Your
related to
state.
you.
I'm just
They
saying, you
send
guys are
Iris to America over here, so.
lately. Texas seems to be trying to become the new Florida man.
Yes, it does. But
Well, since
I
it
always
seems
say I'm Mexican, so not my circus, not my monkeys.
Yeah,
Oh, this is
well,
your circus and
Florida
monkeys. You'll
seems
see.
to have gotten more psychologically stable. It's got that disease has got to go somewhere.
Yeah, I guess. She is a TikTok personality who purports to serve crimes online. We're not going to do jurisdiction. Nobody cares. Factual. In the early morning hours of November 13th, 2022.
Wait, but jurisdiction actually matters because the defendant is in Texas. Where was this filed?
Idaho.
So yeah, that
Oh,
actually
oh my
kind of
God.
matters, but we'll move on, I guess.
Yeah, there's diversity of citizenship. The amounts it's federally filed, or whatever. If diversity of citizenship amount in controversy exceeds 75,000, venues appropriate because Professor Schofield's an Idaho resident. Substantial part of the events giving rise to the claims that it occurred in Idaho.
All right.
So okay. In the early morning hours of November 13th, 2022, 4 students at the University of Idaho were tragically murdered in a home near the campus. It's a tragedy that has gripped the entire university community, forever affected the students' families, brought tremendous sorrow throughout the state of Idaho, and garnered national media attention. To respect the privacy of the victims and their families, the complaint refers to them by their initials. Professor Schofield was not in Moscow, Idaho, when the murders occurred. She and her husband were in Portland, Oregon, visiting friends. They stayed at a hotel, checking out the morning of November 13th after the murders occurred. They drove from Portland to Moscow, a drive of more than 5 hours, arriving after law enforcement officers had discovered the murders. Professor Schofield did not commit or in any way participate in the murders of the 4 students. Professor Schofield has taught at the University of Idaho since January of 2016. She became the chair of the history department in July 2021. None of the 4 students who were murdered ever took a class from Professor Schofield. Although the University of Idaho is a relatively small university, she does not recall ever meeting any one of the students. Professor Schofield has also never met Ashley Gouliard. Ashley Gouliard promotes herself on Amazon and TikTok as an internet sleuth that solves high-profile unsolved murderers by consulting tarot cards and performing other readings to obtain information about the murders. She is purported to solve the murders of musician Kershnik Kari Ball, also known as Takeoff, Shanquella Robinson, Tiffany Valiente, Kevin Samuels, and the November murders at the University of Idaho. Okay. Um, okay. TikTok is a social media platform through which persons can post short videos, typically of no more than 1 or 2 minutes. TikToks are primarily recorded by a person using their own cell phone to record a video and then posting through the person's account on TikTok platform. That was awkward. Individuals with TikTok accounts can review other people's TikTok accounts, can post comments on the various TikToks, and can repost and alert TikTok users' posts. On or about November 22nd, 2022, Gouliard began posting TikTok videos about the November murders at the University of Idaho. She asserted that the murderer had some history with one or more of the victims, and that the murderer was someone who was previously involved with one of the victims, possibly an ex. On information and belief, Gouliard has never been to Moscow, Idaho, or to any other location in Idaho, and that she has no basis to make factual statements about any of the events. On or about November 24th, Gouliard posted 6 TikTok videos to her account in which she falsely stated that Professor Schofield, the chair of the history department, was responsible for the 4 students' death. 2 of the TikToks directly and falsely state that Professor Schofield ordered the execution of the 4 students. 3 of the TikToks either falsely implied or directly stated Professor Schofield had been involved in a relationship with one of the murdered students, KG.
Jesus Christ.
Oh, it gets better.
CCW's got a comment.
Hold on 1 second. 3 of the TikToks Gouliard posted to her website on November 24, 2022, also used Professor Schofield's photo from the University of Idaho website. Upon information and belief, Gouliard did not ever receive permission to use her Professor Schofield's official university photograph. Gouliard's November 24, 2022 TikToks were not based on any facts or any information known to Gouliard. Her statements that Professor Schofield ordered the murders and that Professor Schofield had a relationship with one of the victims are false. On the following day, November 25, 2022, Gouliard posted an additional 5 TikTok videos falsely alleging that Professor Schofield ordered and planned the murders of the 4 students. In 3 of the videos, Gouliard falsely stated that Professor Schofield and a student at the University of Idaho, JD, together planned the murders of the 4 students. Professor Schofield has not met student JD and has not ever had him in class. She has never partnered with him on anything. She did not partner with him to murder the 4 students. Hattie, would you like to read the footnote above?
Given the continuing nature of Gouliard's tortuous conduct, a hyperlink to Gouliard's TikTok account has been provided. Professor Schofield prays for relief against all such false statements, whether specifically referenced herein or created after the filing of this complaint.
Gouliard's November 25th, 2022 TikToks were not based on any facts or any information known to Gouliard. Her statements that Professor Schofield partnered with another student to plan or carry out the murders are false, because let's allege conspiracy.
Yeah, well, you know.
While you're there, you know.
Yeah,
I mean, like, just
all out.
while we're at
There's
it.
nothing better to do.
While we're at it, I mean, like,
Go
why
hard
not?
or go home, you know.
Yeah. Oh, she's gonna go hard soon.
Bet she went to McDonald's and got a cookie too.
And then, held it up at gunpoint over the cookie. On November 28th,
Not that good.
2022, Gouliard posted 6 TikTok videos, which she alleged alleged either by expliciting stately or so posting text with her videos that Professor Schofield participated in or was otherwise responsible for the murders of the 4 University of Idaho students, and that she did so because of her prior relationship with KG. I think that might be a typo there. In one video, she wrote the words, Rebecca Schofield's thoughts as she ordered the murder of the 4 University of Idaho students. Ma'am. Ma'am.
Ma'am.
I just what?
I don't care
We're,
what
we're
y'all
just
say.
getting into the
Let me,
original.
let me do this in the Texas accent. Let me do it the right way. I don't care what y'all say. She did it.
Okay, Debbie, you haven't missed much. We're going over the original complaint, and then we're gonna get into the real stupid.
Yeah, guys, I have not even gotten close.
You
No, I
fixing
didn't.
to
I
go
didn't
for a
skip 20. I
ride
did it.
like a bull rider at the rodeo.
I did do 20. I didn't skip it. I just did it.
Try
Gilliard's
and
November 28th,
refresh there.
2020.
CCW, try and refresh.
Gilliard's November 28th, 2022 TikToks are not based on any facts or any information known to Gilliard or statements that Professor Schofield ordered or in any way participated in the murders or that she was involved in a personal relationship with KG are false. By November 28th, Gilliard had been directly informed that her TikTok videos alleging that Professor Schofield was involved in the murders were false. Nevertheless, she continued posting her TikToks where they were false. In one TikTok video, she wrote, "I don't care what y'all say. Rebecca Schofield killed them." Rebecca was the one to initiate the. Wait, hold on, Iris. I'm gonna need you to read the statement.
Hold on. The which one?
Start with "I don't care what y'all say" and go through her statement.
Oh, I don't care what y'all say. Rebecca was the one to initiate the plan and hired JD. That looks like Dallas, like that 90s novela.
Yeah, I just figured the Texas accent will make that one better. On November 29th, 2022, Professor Schofield, through counsel, sent Gouliard a cease and desist letter informing her that her TikTok videos stating that Professor Schofield was involved in the murders or that she had a romantic relationship with KG were false and defamatory, demanding she take down her defamatory videos, demanding that she cease making such videos, and demanding that she issue an apology to Professor Schofield. Patty, we have a footnote.
The complaint uses the initials J period .D period to protect the individual's privacy and not perpetuate Gouliard's false statements.
Okay, and we have another Thomas joke. We missed the one about the magic Moab.
Okay.
Because it's way better than Magic 8 Ball, apparently.
Okay, let's get through this section, then we can laugh at the things. Gouliard did not stop posting defamatory TikToks falsely stating that Professor Schofield was involved in the murders, that she had a romantic relationship with KG. Ma'am, when they say the lady was in another state, maybe we should reevaluate this and not double down, triple down, keep going. We can probably get off that path. No, not so much. Okay, great. Great.
It's a one-way street.
I'm just okay. You do you, boo. On November 29th and November 30th, my birthday, Gouliard posted additional TikTok videos falsely stating Professor Schofield was involved in ordering and directing the execution of the murders of the 4 students. She was not. Sweetheart.
Yeah, that needed to be made clear.
Sweetheart, the doubling down is not helping you. This does not mean, keep saying the defamatory things. When you're proved wrong, shut up.
Yep.
You are digging yourself one hell of a hole. You're going to hit China at the rate you're going.
Oh, no.
Do not bring China into
this. She popped up in the bottom of the Indian Ocean and is now hauling major ass in the direction of Alpha Centauri.
Yeah, I don't know where you're going, but you may. I know I always say keep it 100, say with your whole chest. This might be the time that you just want to take a step back. Oh, okay, you do you, boo. Since December 1st, 2022, Gouliard has continued making false statements in her TikTok videos, falsely asserting Professor Schofield's involvement in the murder of the 4 University of Idaho students, and falsely stating that Professor Schofield was involved in ordering the murders and was present in Moscow, Idaho, to ensure they were carried out. she falsely stated, inter alia, that Rebecca Schofield's going to prison for the murder of the 4 University of Idaho students, whether you like it or not. I'm not worried about Rebecca Schofield suing me because she'll be using her resources to fight for murder cases. She ordered the execution, the murders of the students.
Wow.
The Professor Schofield's motive in ordering the murders and finding someone to carry it out was because she was dating a student. Professor Schofield decided to kill the students because KG wanted to take a break in their relationship. Professor Schofield was going to help the person she hired to carry out the murders achieve the person's dream of playing on the University of Idaho tennis team.
What?
Hold on. I'm gonna get to the end of this little thing, and then hold on. JD killed the 4 students because Becca told me to, and a reporter with the Spokesman Review newspaper was protecting the killer in the article, suggesting that TikToks are false. Ma'am.
Wow.
Ma'am. You know what, Iris? You're the paralegal. Would you like to interject first?
From what? She's batshit. I don't know what.
Not only are you that crazy, how hard can you double that?
I would have
You're
gotten more than just
delusional.
been playing on the tennis
Okay.
team.
We're not
And then
worried
that's the
at
other
this
thing.
point, Loki. She's not doubling down. She's just tossed a half dozen doubling cubes and went with that.
But here's like the thing. They did it to get on the tennis team. I'm sorry, if you're gonna hire me to murder 4 people, I might need more than a spot on a tennis team.
On the B team also.
I know,
Well,
right?
like I might need a lot more than that. That does not seem like it's going to help you much. Does the tennis
Dude,
team-
just sleep with the professor or the coach. That's what everybody does.
does the tennis team matter that much to you that you're willing to risk capital punishment? Like I have questions that like you came up with this. You're like the tennis team. That's what I want for it. It's like if I asked my
Probably
little
like-
person,
She's
she would
probably
be like, "I
related
want a
to
Barbie."
Uncle Eddie from Murdoch Trial. Like he just did it for nothing. Like, sure, I'll shoot you.
It's like my 5-year-old knows to ask for more than that.
She knows to ask for McDonald's cookies as well.
No, probably a Pokemon or something, but I don't know. Patty, your
Uh,
thoughts?
So obviously, she consulted her magic 8-ball, pulled out her tarot deck, and then drank a 5th of scotch and doubled down on everything.
I don't
Is-
even.
What? No.
Started a fire,
Doubling
looked into
down,
the smoke.
Like I just have questions. But the worst part
Yeah,
is,
my first question is who pays her to be a psychic?
we will get there. Trust me. In her, just hold on to that thought.
Wait
What I'm
for
going
it.
to point out, as batshit as these,
Oh, yeah.
like as batshit as this defamation complaint is, it is comparing apples to hand grenades. As with Gilliard's prior TikToks falsely stating that Professor Schofield was involved in or ordered the murders, her December TikToks have no basis in fact. They were false. No shit, Sherlock. Persons with TikTok accounts can comment on the TikTok posts of others they follow. Many TikTok users warned her that her statements were false and she was defaming Professor Schofield, among others. Gouliard did not stop making false and defamatory TikToks, despite being warned of their falsity multiple times by persons commenting on her TikToks. I have a question. Is the TikTok psychic really named Katie Joy Paulson without a crystal ball?
No.
Because this is out of the WACB playbook. Out of that playbook. Somebody has me on in the background. I can hear myself echo.
Not guilty.
Equally concerning, other TikTok users commented that they believed Gouliard's false statements that Professor Schofield ordered the murders, that Professor Schofield was romantically involved with KG, and that they wondered when she would be brought to justice. On December 8th, 2022, Professor Schofield, through counsel, sent a secondary cease and desist letter, enclosing the first and again demanding that she take down the defamatory posts and that she stop making defamatory TikToks. Rather than change her conduct, Gouliard made a TikTok showing the cease and desist letter and acknowledging she received it. Oh, look, it's Christopher Boozy all over again. And
What?
explaining that Professor Schofield, through counsel, believed that Gouliard was making false statements counsel would need to file actual legal documents in federal court asking me to remove it. A judge will determine if I need to remove it. Ma'am, please do not take a page out of the Christopher Boozy playbook. Okay? Taking pictures of the process server and posting them to your Twitter, announcing on Twitter that you're looking at the process server trying to serve you while you're trying to duck service, and then calling 911 for the on the process server to have police come to deal with the process server while you're inside the house is not helping your I was never served argument. So please do not I'm sorry.
But
That
Loki,
is not the playbook.
a judge will then determine if I need to remove it or not. With the
But
attitude.
I just love it. You're trying to claim you were never served, but then you're posting it. Houston, Danger Will
Such a-
Robinson.
An intelligent woman.
Houston, we have a problem.
Yeah, we have more than one. Also, after receiving the cease and desist letter, Gouliard on December 18th and 19th posted more than 20 new TikTok videos, falsely stating that Professor Schofield was involved with KG, and that Professor Schofield's motive for the murders was to keep KG from making the relationship public. Are you that good in bed that, they're gonna take a murder rap for you?
Are you asking me, or is that
No, I'm just saying to, them. I just got a question. If you're
She
gonna
must
take
have
4
special
murders,
skills.
if you're gonna take 4 murders over
Very
getting laid,
special
I have questions.
she works
Special
it.
skills, Loki. Special skills.
You must. I'm just saying.
She's
Gouliard,
lost it.
Gouliard has continued to publish false statements about Professor Schofield on TikTok, despite having no basis for making those statements and despite being notified numerous times that her statements are false. Professor Schofield has never met Gouliard. She does not know her. She does not know why Gouliard picked her to repeatedly falsely accuse of ordering the tragic murders and being involved with one of the victims. Professor Schofield does not know that she has been harmed by the false TikToks and false statements. Gouliard's false TikToks have damaged her reputation. They've caused her significant emotional distress. She fears for life and the lives of her family members. She has incurred costs, including costs to install security systems, security cameras at her residence. She fears Gouliard's false statements may motivate someone to cause harm to her or her family members. Okay, let's comment, guys. Okay. Y'all can start. I'm going to look through the comments while you guys start with your comments, and then we will.
Yeah, no, that lady was getting death threats for a while there.
Oh,
Until they found their actual suspect in
Pennsylvania.
Pennsylvania.
Oh my God,
that's great.
Patty.
I have predictions. I'm not psychic. She's just it's all that in a bag of potato chips. It's just yeah.
Of course she is. She has the collection of magic doubling cubes. She grabs it, and she's a big thing about the size of her head, opens it up, dumps it out, counts all the faces that she can see, adds it all up, and then goes there instead of merely doubling down.
And all for the tennis team.
I know, right? What's up with that? That tennis team.
The tennis team and to keep getting laid.
So is that what Serena and Venus had to do?
I don't know.
Serena, maybe.
I just I'm slightly confused.
Completely conjecture.
Oh, of course.
I'm confused. It's like, what are you doing? Where? What?
And just out of nowhere, do you know why she chose her?
No, nobody knows.
Oh.
Well, it's
Nobody
probably
knows.
because all she did was what she did here was she went through the faculty list and went, I like that one.
Damn.
I mean,
Maybe this professor gave her an F, and she's like, "All right, bitch, I got you."
Well, actually,
this lady's never even met her.
I don't think our defendant on this side has ever been to Texas or has ever been to Idaho.
Hey, Debbie, hope you're
Yeah, no,
feeling better.
that's what it said, that she'd never met her, never been there, never anything. But that's wow.
Oh, maybe she just like spun one of the like the roulette wheels, just like put up pictures of different professors, gave it a spin,
And through the dart.
threw the
And
dart.
make the rest of the
She did
story
something.
straight out from there.
Wow.
Go intellectual. Golden Girl, you have no idea how much we're about to double down. The casting couch. Wait. Okay. This is why I love my chat right here. Hold on.
I've got Crown Royal right now.
The Ouija board. She used a Ouija board. There we go. Hold on. Let's see if we have any other ones.
Thomas, this is the one that was actually written by the lawyer. This is the original complaint. We have yet to get into the eventual reply.
Yeah, this is literally just saying what she did. Like, look, she said this, so we're suing her because she's defaming this professor. So,
and that professor actually, from what I have been told by people who were in a position to know, she very nearly got fired.
Yeah.
I mean, we're talking about a tenured professor.
There you go.
Sometime. Fully in the.
I told you she could work
in the position of you're going to get fired like now.
Wow.
Andrea. Oh, sweet Jesus, it gets worse. Might be one of the biggest understatements I've ever read. Just trust me.
This is the same half.
Guys, this makes the most sense this is going to make, okay? Oh, wait, here we go. There you go.
I think the lawyer's actually got his head together. It's our defendant in this complaint that is that has the problem.
Yeah, we will see.
So this is a complaint. She didn't answer. They did a default, and then she answered.
Yeah, I'll get to that as soon as I get to the end of this for everybody.
All right.
Professor Schofield realleges incorporates by reference all prior paragraphs of this complaint as if set forth in full herein. In her TikTok post between November 24th and present, she's still going. Oh my God, someone shut this woman up. Gouliard made false and defamatory statements and Professor Schofield and the murders of the 4 University of Idaho students more than 40 times. Ma'am,
go
they
hard.
can charge you for every time. They don't have to charge it as one.
Yeah, 40.
You can charge for every statement. Okay, you do you, boo. If you're trying to outdo Myrtle on how many charges you can have pending at once, you get in there. As Gouliard's false statements involve criminal accusations, they are per se defamatory in nature. Iris,
correct.
would you like to explain per se defamatory?
Well, they're talking about her, so she's not. Sorry, I've had stuff to drink. She's not a celebrity, so all she has to do, it doesn't have to show malice. So just whatever the statements are, this is it. So those are the statements. It's defamatory. It's not true. So there you go.
Perfect. Well, we talk about so much like with malice because the public figure thing. I knew someone would ask.
But she's not. She's not.
Oh no, I know she's not.
So
but I'm saying people.
You don't need that level. You know.
Oh yeah.
So
but I knew someone would ask.
Yeah.
Because we usually don't see it. Gouliard
Sanji, stupid hasn't even started. We're on the same side.
Just hold on. Gouliard knew her statements were false because she had no knowledge about anything happening in Moscow in and around November 13th. Gouliard further knew her statements were false because they were not based on any facts, because persons commenting on her post told her they were false, and because Professor Schofield twice sent her cease and desist letters regarding the false and defamatory posts. Gouliard's false TikToks defamed her because they were viewed millions of times and widely were posted by other TikTokers, resulting in Professor Schofield's name being linked to murder in a basic internet search. As a result of the false statements, her reputation was injured. She was subject to online ridicule and threats from Gouliard's online commenters. She also fears that she or her family will be the target of physical violence. The online nature of Gouliard's first statements continues to harm and damage Professor Schofield. Gouliard's TikTok account has more than 100,000 followers And some of her TikToks defaming Professor Schofield have 2.5 million likes, indicating the person has viewed it and liked it. Professor Schofield has been damaged by Gouliard's first statements. Her reputation has been tarnished, and she has suffered extreme emotional distress from the constant public attention and the ongoing online conversation regarding her role in the murders as falsely alleged. Second claim for relief. Oh my god. Professor Schofield realleges and incorporates by reference all prior paragraphs of this complaint. In her TikTok posts, she says she was romantically involved with students. We're going to go through this part a little bit quickly. With some of them. As Gouliard's statements involve moral turpitude, a professor being involved with a student, they are per se defamatory. Gouliard knew her statements were false because she had no knowledge about anything happening in Moscow, Idaho, or at the University of Idaho. She doesn't know the professor, she doesn't know KG. Gouliard further knew her statements were false because they were not based on facts, because persons commenting told her, and she got the cease and desists, and she said, "Nah, fam, I'm gonna keep doing it." Okay, so this is the same
She
thing.
didn't know the professor. She didn't know Idaho. She didn't know the college. She doesn't know what world she's in. Just everything.
I don't think she knows her.
World. I don't think she's even in the same universe at this point.
I don't think she knows her ass from a hole in the wall.
Go Texas.
I'm just saying. Yeah, okay, so they were millions of times they were viewed. Same emotional distress. She wants attorney's fees, so pray her for relief. Professor Schofield prays for judgment in her favor and against Gouliard, as well as compensatory and punitive damages in an amount to be provided at trial. Attorney's fees, costs, and disbursements incurred here. Pre-judgment and post-judgment interest, and all such other relief as the court deems equitable, just and equitable. Professor Schofield requests a jury trial of not less than 12 persons as to all issues triable to a jury.
So those 12 people can also say, "What the fuck?"
Okay, so let's all comment on the sane filing, because the sad part is this is sane. Any thoughts?
Yeah,
No, it's
this
not.
is the sane part.
Sorry.
Maybe
Yes,
she
Kel.
thought that she was in a game of Clue. You know, the professor did it with a knife in the living room or something. I don't know.
I don't think we're actually going to get as far as a copy of Clue. She claims to be
Go,
some sort of
Opal.
interweb sleuth, but
She's not that competent.
no, she'd have to be more competent.
Yeah,
She'd have to-
yeah.
Okay, scratch that. She'd have to have more than half a brain cell.
Yeah, half is being generous. I'm just gonna put that one out there.
Not in Texas. Half a
Okay.
brain cell? That's a lot.
Yeah, I've been to parts of Texas. So yeah. Okay, so here's where this gets funny, guys. The professor files this complaint. You have 21 days to answer, right? She doesn't bother to. The psychic literally is just like, "Nah, fam, I don't feel like doing it." You generally, as Iris can attest, you generally just don't ignore things like this.
No,
They don't
you
go
look for that
away.
screen, right? The minute they gave you the paperwork, you're like, okay, who do I call?
Yeah, you don't just ignore it and be like, "Nah, I'm good," and keep doing it. Okay, so we wait 21 days, and the court clerk enters a default judgment. You didn't answer, so they win by default.
Mm-hmm.
Now, here's the thing, and Iris or Krakow or Patty can attest. If you default on something like this, you go beg the court to give you an extension.
And this
Or
is
you
federal
file a late
court.
response.
And this is federal
Yeah,
court.
Kel Marie.
You
don't
beg,
like-
you beg on your knees in federal court if you miss the deadline, any deadline. So you just you beg. In state court, it's like, "Judge, I'm sorry, whatever." In federal court, it's like, "Nope," just straight up, "Nope."
Right. Kel, yes, the nutty psychic is claiming to know about the murders, but not only is she claiming to know things, she was claiming that she knew for a fact it was this professor that did it, why the professor did it, and about the conspiracy.
Yeah.
Okay? So, yes, Opal. Yeah, Golden Girl, this gets worse.
Oh,
So
you
here
in
we go.
trouble, girl?
Ooh,
Yes,
you
Golden Girl.
trouble girl.
Here we go. Here's what the funny thing is. So instead of getting on her knees and begging, this dipshit, and that's the nicest thing I can call her, goes and files a countersuit. She doesn't even bother to answer. You're not going to answer the complaint. You're just going to be like, nah, fam. I'm not answering your complaint. I'm just going to file my own lawsuit. That's not how this works.
No, it's not.
I'm not
how
a
this works.
paralegal
It'll
or
never
a
be how
lawyer,
this
but
works.
Iris, that's not how
Nope.
this works, right?
That is definitely not how this works.
Okay, yeah. She's
Well,
like, no, fuck you. I'm not going to.
she's in
I am
another
not doing
reality,
this.
so it might work.
I am not answering. I'm just going to file my own lawsuit.
Oh, no, she didn't.
She
You
that reminded me
might.
like, what is it? I'm rubber, you're glue. Whatever you say bounces off of me and goes back to you.
Like, I don't know, but like, you may
Next
want
to
to at
you,
least
yeah.
fire.
When someone says Cthulhu has told me so, say,
Yes, Andrea, because it's like you might want to answer that complaint. Like, if you want to answer the complaint and then file your countersuit, like, go for it. But you didn't even bother to
No.
answer the complaint. Okay. So
The
this is
stable
gonna go
is
well.
different.
Like I titled the stream, the psychic couldn't predict how this is gonna go.
So
Yeah.
before we
I
carry on,
just
I have two questions.
sure.
One, why have we not seen news stories of her having won the Powerball the last 25 times or more? And two, if she's that good a psychic, why didn't she say something before it happened? Clairvoyance, you should be able to pull that off by its definition.
Okay, the Powerball is a lot of psychics trying to get that one. So she had competition. But the Texas Lotto, she should have definitely won.
She should have been able, but it would seem to me that if she's this clairvoyant to pull a random individual out of a freaking hat and make all of the accusations, she should have been able to prevent it completely.
Whoever has their stream on in the background, mute it.
I do not.
I do not.
Okay.
Nope.
Okay. I don't either, so I don't know why there's an echo. Okay, whatever. So here we go. Everybody buckle up, hold in, strap yourself down, hold in, get your beer, get whatever, move your electronics so you don't spit things out.
Wait, I need another drink. Hold on.
Okay, go get your other drink. Iris, get your
not
drink.
possible in these spaces that I have to work with. And I don't have any booze. I'm fresh out.
Comments are
okay, scratch that. I've been out for a while now.
But the comments are gold tonight.
Let's look for a few of the comments while we have Iris getting her drink and stuff.
And this is the Ninth Circuit, folks. She thinks she's going to get away with this.
Oh, because we need Iris back here. So for this part of this, everybody, okay?
Here, I'm just getting my drink. Y'all,
No, I know. I'm just saying. I just.
You may proceed.
This guy, guys, I am going to read this. My lovely panel members, please feel free to just yell Loki, stop, and interject. Or just interject, okay? Because this is a ride.
Can I start right here with the versus bits? You're not only gonna sue the professor, but
I'm getting there.
4 lawyers,
Just hold on.
and
Just
but
hold on.
all 4 of her lawyers.
So this genius, this absolute genius is like, yeah, no, what I'm not going to do, fam, what I'm not going to do is respond to the complaint. But I'm going to file my own. Okay. So I'm going to sue, and now mind you, Miss Gouliard, the TikTok psychic, not only am I going to sue the professor, I am going to sue all of her attorneys individually and the law firm.
Right, that's not a thing, but okay.
It
What?
could be a thing.
Good try.
It could be a thing.
Good try.
Okay.
That one-way street just keeps getting longer.
I'm just saying.
Actually, it says Stoll Reeves. I don't think she's actually. I don't. She may think she's suing the law firm, but I don't think that's actually the way that works. I don't think.
She just she did, and she did file this pro se.
I want to know what Iris thinks of that of the versus section because wow.
Of the what?
He wants to know what you think about her being like, I am going to sue her attorneys and the law firm too.
Oh, she's a dipshit. Yeah, no, I mean there you go.
Well, read the list of people she's suing. Is she actually suing the law firm or just the individual members?
No, she is due.
Let me read it.
I'll read it. This is the document I have. It's been fixed. She's not only suing them individually. She did add the.
Oh, she added the law firm after this was done.
Yeah, because where it says of Stoll Reeves, it now just says Stoll Reeves.
Wow.
I'm going to scroll past that little bit because it's got her personal info. Even though this is out there, I'm just not going to be the one that puts it out there. So here we go. This is going to be a literary masterpiece for everybody. Feel free to interject. Iris, feel free to scream at things. Trust me. Everybody. No, Kill, she's not a sob set. She's just stupid. Defendant counterclaim plaintiff Ashley Gouliard submits the following answer, affirmative defenses, and counterclaims to plaintiff counterclaim defendant Rebecca Schofield complaint as follows. Paragraph 1 of the introduction of the complaint contains a narrative for which no answer is required. In November 2022, 4 students at the University of Idaho were murdered at a home near the campus. The tragedy has garnered attention and inflicted great sorrow throughout the university, the state, and the country. To the extent that an answer is required, Ashley Gouliard denies all allegations in the introduction.
Well, she starts off good.
Oh, but here's where it gets funny. Ashley Gouliard partially denies the allegations in the first sentence of paragraph 1 of the parties portion of the complaint pertaining to the allegation that Rebecca Schofield is an individual. Ashley Gouliard admits the allegations in the second sentence of paragraph 1 of the parties.
If she's not an individual, what, hold on. 80? What the hell?
Ashley Gouliard admits the first sentence in paragraph 2 of the complaint and denies the remaining allegations contained in the. You're denying you're a person.
What? Oh, okay. I mean, people have been called dogs, but I mean, still. Like,
you literally. Idiots. You are denying the parties. You are denying
an individual.
Wait. Is that lawful law or is that just box fort material?
Maybe she's a twin. So, you know, not an individual.
I don't know. Oh, wait. Hold on. Guys, hold on. I got to do this. Hold on.
Denies.
Good evening, ladies and gentlemen.
Hey!
Okay.
Hey, John.
So, John, now that we have you here, hold on. I'm going to reread this first page.
Would you be so kind as just to give me a little bit of the background? Because I
missed yes, I'm going to give it to you right now.
The stream.
The psychic is from Texas. That's pretty much it.
Yes. So
he's a psychic from Texas who's on TikTok.
A psychic from Texas who is on TikTok alleged that a professor at the university conspired with somebody else to murder the University of Idaho students, and the reason they went along with it is because they wanted a spot on the tennis team, and that they were having a relationship. But
he coveted tennis team.
Yeah, on the tennis team. But the professor has not only never met the lady in Texas, she has never met or had any of the students in class, nor does she know the person she's supposedly in a relationship with. And 3, she was in another state when the murders happened. So she's being sued for defamation. They sent her a cease and desist, and she doubled down and made 40 more statements saying, no, I'm right. And if you want me to shut up, take me to court. And the judge will tell you I'm right.
No, yeah. She says, I don't care what y'all say. I'm right.
I'm gathering that this is the answer.
Yes. And on top of this, John, wait, we're going to get this part from John.
They got the default.
So
she
John,
missed the answer date.
she defaults. She's like, fam, I don't feel the need to answer. She
Okay.
defaults. The court clerk enters the default. The next day after the court clerk enters the default, instead of filing anything, she files this counterclaim.
Oh, okay. So this isn't an answer. This
We're
is
not
after
going to
default, she's filing a counterclaim.
Yes, but we're not going to respond to the first one, and it's in default. So we're going to start reading
what
this again.
state is this filed in?
This is in Idaho right now, but hold on. I'm going to read this and wait till I finish reading the introduction and parties. And you're going to interject for sure, okay? So here we go. Defendant counterclaim plaintiff Ashley Gouliard, the psychic, submits the following answer, affirmative defenses and counterclaims to plaintiff counterclaim defendant Rebecca Schofield complaint as follows. Introduction. Paragraph 1 of the introduction of the complaint contains a narrative for which no answer is required. In November 2022, 4 students at the University of Idaho were murdered at a home near the campus. The tragedy has garnered attention and inflicted great sorrow throughout the university, the state, and the country. To the extent that an answer is required, Ashley Gouliard denies all allegations in the introduction of the complaint. Parties. Here's where you can tell we have a problem. Ashley Gouliard partially denies the allegations in the first sentence of paragraph 1 of the parties portion of the complaint pertaining to the allegation that Rebecca Schofield is an individual.
No, that's not how anything works. What is she?
What?
A plant?
You don't say.
You're denying she's a person.
I mean, you know, is she an alien? Is she
Thank you.
a rock?
She's a
Even
twin.
if she were an alien, she would still technically be a person.
You are denying that the professor's a person? What?
All right. Well, that's not probably what you want to deny. It would be interesting to compare the two documents, but okay.
I've
We
been
did read the
coerced.
first one already,
Actually,
but
complaints before I got on, but
I did. I read the entire complaint. But
Right.
hold on.
If she's
Okay.
not a person, then what is she?
a rock,
No.
a tree.
I don't know.
She's an
Primates.
Ashley Gouliard admits the first sentence of paragraph 2 of the complaint and denies the remaining allegations. So the professor isn't a person, but she is?
Yes.
Okay. Here we go.
Why is that the thing that you partially deny?
Jurisdiction and venue. Yeah, I mean, Ashley Gouliard denies all allegations in paragraph 3 of the complaint. Ashley Gouliard denies all allegations in paragraph 4 of the complaint. So you are denying the jurisdiction being Idaho because all the stuff took place there.
But that's
Here's
not
the
how that
problem.
works.
If you're going to contest jurisdiction, you don't file. John, you're the lawyer. You correct me. You and Iris are paralegal. You
file
probably
another
shouldn't
motion.
file a counterclaim in that same court if you're saying they don't have jurisdiction.
No, you should not.
Because then you're conceding it.
What you're supposed to do is you're supposed to file a motion to dismiss based upon jurisdiction and venue, or raise it as an affirmative defense in your answer. But if you fail to file an answer and you're now filing a counterclaim, a naked counterclaim, because you never answered the actual complaint, you're basically conceding venue. And you're at the very least, you're at least conceding jurisdiction. This
Because
isn't.
you
This
went and
isn't
filed it
answer-
in that state.
This isn't. It's an answer and counterclaim, but it's an untimely one. So
Yep.
if you're untimely when it comes to jurisdiction and
federal.
venue, you waive them.
Yep, and it's federal.
And then
I
filing the answer also waives it.
Right, and then you went and filed it, so you waived it now because you're
Well,
filing in
no,
court
because
that
you
you're saying
can
doesn't have
raise
jurisdiction.
jurisdiction and venue by filing the answer. You can absolutely do that. I mean, if you argue, poor service, for instance, in your answer, you're not waiving it by answering. It's, I never heard about this shit. It was just by accident that it happens to come across my information. But yeah, I think that we have jurisdiction and venue because
Well, here's Here's
You're
a fun one for you.
subjecting
You're gonna
yourself.
love that.
That's not even the worst part of this whole thing. So
She actually went on TikTok and said, "Nah, she's not gonna sue me, because she's gonna be too
She
busy
pulled the
trying
Nate
to."
Boozy. She pulled the boozy defense
Yep.
and tried to
Right.
dodge service while posting pictures of the cease and desist on TikTok.
Lovely.
So let's continue. Factual allegations. Paragraph 5 of the complaint, a narrative for which no answer is required. To the extent
Forgive
that an
me if
answer
I
is required, Ashley
smoke and
Gouliard
drink a lot of whiskey.
denies all allegations. Ashley Gouliard lacks sufficient knowledge to admit or deny the allegations in paragraph 6 of the complaint.
Okay.
Wait, here we go. Ashley Gouliard denies all allegations in 7. Ashley Gouliard lacks sufficient knowledge to admit or deny 8. Lacks sufficient knowledge. So we're going to just deny everything, okay? Because that's all that is. I'm not reading that 23 times.
That's what you do when you write an answer.
I know. I'm just saying for everybody else, I'm not going to read
No, I'm
that
just saying
shit.
for the sake of the audience, what you do when you file an answer is you take their complaint, you print it out, and you literally redline it, and you translate it over.
Okay.
And you go, look, admitted, denied, no information sufficient, denied. And that's literally how you write an answer.
Okay. So we are now denying everything under the first claim. We're denying the allegation she's sleeping with students. Here we go. John, Patty, put down anything you could spill because I'm concerned. Ashley Gould,
Glass
affirmative
is
defense.
empty.
Ashley Gouliard, for her affirmative defenses, states as follows. The venue is improper for this case because it impedes upon the interest of justice under 28 U.S.C. 1404. Ashley Gouliard's a resident of Texas. The venue is improper for this case because the events giving rise to the claims of defamation took place on Ashley Gouliard's social media page. There's no district in which this action may otherwise be brought except the U.S. District Court for the Southern District of Texas.
Bullshit.
The complaint stated a claim upon which relief can be granted. Plaintiff's claims are barred by the substantial truth doctrine pursuant to Mason versus New York Magazine. Plaintiff claims are barred by qualified privilege. The 4 University of Idaho students were brutally murdered. Without the arrest of the murderers, there is a presumption of danger to the public. University of Idaho constituents and Idaho residents. Discovering and revealing the murders with the intent to get them investigated and arrested is an act to warn others about harm or danger and to bring resolution to the problem. The statements were made in the best interest of public safety. Ashley Gouliard made the statements without actual malice. Therefore, qualified privilege permits Ashley Gouliard to make this statement
No.
that in a circumstance
Even
would
I know
be
better than that.
defamatory.
Don't
No.
break John. Please
That's
don't break
not-
John.
That's not how that works.
At all.
No.
This is not an
What
incident.
did I walk into?
this is in the best interest of public safety, y'all.
Wow.
Okay.
What kind of qualified immunity
Does
do you get for that?
Does this mean the English teacher's going to make you learn grammar?
Can I make one technical argument just predating this particular stupid, and then I'll respond to this stupid?
Sure.
Go for it.
So she's arguing venue under 1404. And 1404 is a statute that says, for the purposes of the convenience of the parties and the witnesses available, you can say that venue should be transferred from one district to another. That is it's more complicated than that, but venue is one of the more complicated aspects when it comes to jurisdictional law. But that's not this.
No.
All of the witnesses and the relevant parties, except for you, are in Idaho. Even if we want to give this a snowball's chance in hell of being an argument. So that doesn't work from a technical level. Now, when we read this, discovering and revealing the murderers with intent to get them investigated and arrested, to act to warn others about harm or danger, and to bring resolution to the problem. The statements were made in the best interest of public safety. You're an idiot. Ashley Giard made the statements without actual malice. So fucking what?
See, here's the
At what
problem.
point is this the actual malice standard doesn't apply here because the defendant is not a public figure.
Yep.
So what the hell are you talking about? Please tell me this wasn't filed by an attorney.
No, it's pro se.
Oh, thank God. All right. Okay.
Because if that was, I would think that somebody would be up for disbarment hearings if they as an attorney filed this.
I certainly reprimand.
I'm just confused about the fact that she denies she's a person, and I want to know what kind of privilege you have.
Wait, can I point one other thing out?
But no, you can't point it out until you tell me what the hell kind of privilege she gets for being a psychic on TikTok. There's
None.
no
She
TikTok
has no
privilege, as long as
privilege.
I know.
She has the privilege of being from Texas. Other than that, none.
I think being a TikTok
I
psychic
think,
is
I
a
think
handicap.
she doesn't understand the difference between actual malice being an affirmative defense and qualified immunity, which applies to public officials. She thinks she's a public official because she's a psychic.
That doesn't make her a public official. In
I
fact,
can
that makes
agree
her
with you on
exactly
that.
nothing. Except a Miss Coolio level fraud.
I just really want to know what kind of immunity.
Well, she's asking for qualified immunity like she's a cop.
No, she has
Exactly.
qualified privilege.
The attorneys that she's suing have that qualified
Oh yes.
immunity.
Before I forget, John, this countersuit, she not only sued the professor, she sued every one of the attorneys individually and their law firm.
What?
Yup.
Hold on.
Oh,
Hold
you're
on.
gonna break him tonight, Loki. Please don't do that.
Yeah, let's do that.
There you go.
Oh,
Unfortunately,
break John.
Lindsay and Nathan
Rebecca
Lindsay-
Schofield is the professor, right?
Yes.
Yeah.
Look at the counterclaim.
Wendy Olson, Elijah Watkins of the oh my God.
She
Oh
sued
my
them
God.
each individually.
The only people that actually do have privilege here are the attorneys.
Yep.
And
by
you
the way,
sued them
the thing
individually.
that I wanted to point out was, can you scroll up a little bit, please? A little bit more. Little bit more. She relabeled her paragraphs. And I'm sorry, this is a nerd thing for me, but
It's because she's starting a different context. These are the affirmative
that's
defenses.
not how any of that works. Not what you do from a drafting perspective. Sorry, I know that's like really nerdy, but I just noticed that.
I just like that she sued the attorneys individually.
I hadn't
So
noticed it.
I'm going to sue all of the attorneys, and I don't know that I have to maintain consistent paragraph headings. Oh, God.
And CCW, for the record, unfortunately, Mr. Randy contracted a slight case of dead a while back. And our friend here, Miss Ashley, has failed to accomplish the thing she really needed to do, which was a seance with him. Because, yeah, she would have gotten much better advice.
Well, yeah,
I just love
the South
qualified
Park
privilege.
nuance.
I just want to know what the qualified privilege is.
There isn't one.
She may try to explain this, though.
All right.
Okay, let's
It's in
continue.
her head.
Let's give her the benefit of the doubt for now.
Hold on, here we go.
Come on, we've
Plaintiff-
only got 20 pages left.
Oh, this and every one of them are gold. Plaintiff's claims are barred by ready. Plaintiff's claims are barred by the parameters of the broad freedom of expression guaranteed by the First Amendment of the Constitution of the United States of America.
Which does
No.
not cover defamation.
Wrong. The First Amendment does
Absolutely
not
correct.
cover defamation.
Yep.
She should have paid better attention to Depp and Heard issues.
Plaintiffs' claims are barred by fraud because they're false, perjurious, frivolous, and claimed with malice to get away with unethical conduct, adultery, and murder.
What?
Ooh,
Oh
That's
my
a
oh,
really
remember what I
strong
said about
statement.
doubling cubes here a while back? She just broke out a whole new backgammon set.
I
Let's-
told you, she done doubled down.
Oh
That's
my.
doubling down on the defamation.
Yes.
You
No,
have
this
put
is
it
rune
into a
set.
court record.
This is triple down. What the hell?
No. We've got we're right now. We're somewhere in the neighborhood of
We're at defamation session.
of 2 to the 150 millionth.
Like, I just love
Wow,
that
this is a
the
one-way
claims are
street
barred
to
because
hell.
she murdered them.
It's 2 times 10 2 times 10 EE 150 million.
This lady's one-way street is straight to hell. I can't believe she said that.
Like, I just,
Okay.
what? What?
Yes, Sparkling Dragon.
Like a poor
And your
decision.
opal left. That's unfortunate.
I
We've
I
had a-
don't understand, like, how we. What? She can't.
But
she
here's
can't sue me
the
for
thing is
defamation.
that she literally just engaged, even if we want to presume that these folks are I would say limited. I'm broken. Hang on, give me a second. Even if we want to
Limited
assume that these
public
are
figures.
limited purpose public figures, you literally just gave you literally just stated 3 of the things that are malice per se.
Oh, yeah.
You
And she's
accuse them of
also done
unethical
it
conduct
40
in their
plus times.
business, unethical conduct in their business, adultery, and murder.
All
All of which are literally defamation per se by definition.
Okay, wait. Just hold on, and then you can lose it. Ready? Plaintiff's claims are barred by comparative negligence. The plaintiff, Rebecca Schofield, committed the allegations that the defendant, Ashley Gouliard, alleged as they are substantially true. The plaintiff, Rebecca Schofield, is at least 51% at fault for being accused of the allegations. Therefore, the plaintiff,
Oh
Rebecca
my
Schofield,
God.
may not recover damages.
What?
Oh my God.
No. Brain.
Oh my God.
My brain is escaping. It's
Sorry,
left.
I
It's
don't
run
wanna,
off down
I'm
my-
actually going to mute myself this time, but I need to go scream into the ether first.
No, don't. It's good. You don't have to mute yourself.
Wait, stop. Wait, I'm not done laughing. Hold on.
No muting.
Wait, so the professor is at fault for this?
counterclaim.
Yes, the professor is now at fault for her making the accusation.
That's not how any of this works.
That sentence alone deserves a drink. Just if you have it, drink it. I don't know what to tell you.
51%. You're 51% at fault for me accusing you of something false.
How the hell does that even? That math does not fly.
By the way, not for
That
nothing,
math does not fly.
I don't even think that comparative negligence is valid in
Loki,
that district. I think it's a I don't think contributory negligence is even. Does
Loki, you're 51%
contributory
at
negligence
fault.
even exist in the federal
I
system
know.
anymore?
You're 51% at
it's
fault,
in-
Loki, for us having to read
It doesn't lie.
I know.
Okay.
But I read this and I'm like, you're at fault for me accusing you of something. What?
I mean, is she trying to get at truth? Is that her argument?
I don't.
No.
She's
It's
trying to
over
get
design.
contributory negligence where that she may not recover damages. Contributory,
Over
not
design.
comparative. But
No,
she said,
I understand the difference between contributory and comparative negligence.
yeah, but that's what I'm saying. Like she pled the wrong thing, and it's not even. There's no way. There's literally no way. It's
No,
You're at
what I'm
fault for
saying
me
is, I
accusing
think
you.
that the federal rules are comparative negligence, not contributory anymore.
yeah, but she doesn't even know that.
Okay, but I just want to know how you're at fault for me accusing you. What?
You're at fault for me reading this.
I know I
Your
am.
argument would be the truth of the statement. That's how you have
51%.
that's how you have contributory negligence, but that's called an affirmative defense. It's not. This is not Defamation is not a negligence standard. Oh,
Okay,
God.
let me read 9 and 10, and then we're gonna do one really quick thing. Hold on.
The tech stream is tomorrow, CCW.
No. CCW, you and I, you can drink tonight. I'll do it with you in the morning, if need be.
I still
9.
gotta finish the cross-examination.
I got to mute so you don't hear crunching. Dog's having
Okay.
dinner.
Hold on one second. Plaintiff's claims are barred by illegality because they are perjurious pursuant to 18 U.S.C. Plaintiff's claims are barred by illegality because they're claimed with the intent to obstruct civil justice and with the intent to obstruct criminal justice.
No.
John, here's your turn. And John, go ahead and tell everybody who you are before I forget, and your channel.
Yeah, my name is John. I run the channel J. Robine Law. I am an attorney. I am licensed in both the states of New York and Florida. And I do a little bit of everything. Some of it is covering trials. Some of it are more fun streams. And everybody seems to enjoy when I lose my mind. So there's that.
That happens often.
That's me.
Okay, so what do you think about that last one? That last paragraph?
I would like you to go back, and I'm going to look up the statutes that she cited.
Would you like me to scroll up?
Would you be so kind? I just want to look up the two statutes, 1621 and 1503. All right, you can continue. I'm going to look these up.
Oh, here. No, wait. You just hold on. Before you look them up, just let me read this paragraph to you, John. Counterclaim plaintiff Ashley Gouliard brings these counterclaims against counterclaim defendant Rebecca Schofield, counterclaim defendant attorney Wendy J. Olson, counterclaim defendant attorney Elijah Watkins, counterclaim defendant attorney M. Carone, attorneys with Stoll River LLP in Boise, Idaho, and alleges follows. So yes, we are also suing the lawyers.
Yes. All right. So let's just go with 1503 because I don't want to be too nerdy. I just want to give an example of how not to use a citation.
Like this?
Would you mind if I shared my screen for 1 second?
No, go for it.
Okay. So 1503.
Hold on. You gotta.
I got
see
it.
Oh, okay.
I got it. I can do that here.
Is influencing or injuring an officer or juror generally, whoever corruptly or by threats or force or by any threatening letter or communication endeavors to influence, intimidate, or impede any grand or petit juror or officer in or of any court of the United States or officer who may be serving at an examination or other proceeding before any United States magistrate judge or other committing magistrate in the discharge of his duty or injures any such grand or petit juror in his person or property on account of any verdict or indictment assented to by him or on account of his being having been such juror, or injures any such officer, magistrate, judge, or other committing magistrate in his person, property on account of the performance of the official duties, or corruptly, or by threats of force, or by threatening letter or communication influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due administration of justice, shall be punished as provided in subsection B. If the offense under this section occurs in connection with the trial of a criminal case, and the act in violation of the section involves the threat of physical force, the maximum term of imprisonment which may be imposed for the offense shall be higher than that otherwise provided by law or the maximum term that could have been imposed.
And
This is now my tip off, and I'll stop sharing that one. My tip off was she's citing 18 USC, which is the federal criminal code.
Oh yeah, it's all criminal. Yeah,
That's
she's
why-
criminal.
That's why I absolutely knew that it was going to be stupid. If anything,
Oh, that was your tip off? Nothing before that was your tip-off.
No, I mean, there's plenty of things in my tip-off, but in terms of that particular one, and I can go to the 1620 as well, but I don't want to derail the
It's
conversation.
perjury.
But the problem that you have is that's literally what you're doing right now. You are the one who is legally impeding in your counterclaim. If you really want to make the argument, you're the one who's impeding the administration of justice, you moron.
You know these attorneys are like, what is wrong with this bitch?
Was it 16? Was it 16?
We know what's wrong with her. She's pro se. That's what's wrong with her.
And honestly, it really wouldn't apply to her either. Because I think it would be hard to argue that it's corrupt or by threats or force. But, oh God almighty. It's like, if anyone's doing this, it's you.
Okay, so back to the fun.
All right, sorry about that. That was your brief educational moments. The more you know.
Loki,
I have a question. I have a
Loki's
question.
like,
for John.
okay.
I have a question for John. How did any, assuming of course that we're talking about skip the criminal part, how would that citation mean a fracking thing in this context? Skip whether this is civil or criminal court. Where in any of that would that apply
she alleged
to?
the professor isn't a person, and you're wondering the difference between jurisdiction?
Fair point.
She denied it's a person.
But here's where we're gonna. I will answer that question to the best of my ability, even though my brain is fried on that one. It wouldn't, and the reason is because the defendants, the person who has to be influenced has to be a juror, a grand juror, or an officer of the court. She is not one of those. So it's utterly irrelevant.
I don't think she cares.
Back to the fun.
Oh boy.
Nature of the counterclaim.
Opal
set
has
forth-
actually missed his friend Sparkling.
As set forth more fully below on December 21st, 2022, Rebecca Schofield and attorneys with Stoll Ribs LLP in Boise, Idaho, and then they named the attorneys again, filed a complaint against Ashley Gouliard, notwithstanding the fact that the claims are false, defamatory, and with the intent to obstruct justice for this case of the murder of the 4 University of Idaho students. Ashley Gouliard was the only person aware of Rebecca Schofield's role in the murder of the 4 University of Idaho students who spoke up about it. To stop Ashley Gouliard from promulgating her testimony of Rebecca Schofield's role in the murders and to get away with murder, Rebecca Schofield and her attorneys filed a frivolous, perjurious, and defamatory complaint against the Tik Tok Psychic.
Oh my God.
Oh my God.
Perjury wouldn't even apply here because that actually requires you to lie to a court of law in some way, shape, or fashion. Am I wrong here?
Yes, you need to be under oath in order for perjury to apply.
Right. So there's no perjury here. You're the one.
The only one that.
And by the way, notice that she started the paragraphs again.
Can you go back up to 1? She literally said it again.
Mm-hmm.
She's
literally defaming them in this court document.
Mm-hmm.
She was the only person aware of the professor's role in the murder. Oh,
How?
Wow.
Citation fucking needed.
That would be helpful.
Wow.
I told you it was epic.
I
Attorney Wendy J. Olson and Rebecca
Go ahead.
Okay. Attorney Wendy Olson and Rebecca Schofield collectively executed a strategy to discredit, embarrass, humiliate, and assassinate Ashley Gouliard's character by disseminating false statements in a press release that was disseminated worldwide into most of the major news outlets across America, beginning late December 2022 and continuing into January 2028. The false statements made by the attorney and Rebecca Schofield include a false statement that Ashley Gouliard decided to use the community's pain for her online self-promotion, a false statement that Ashley Gouliard made false statements about Rebecca Schofield knowing they were false, a false statement that Ashley Gouliard had no basis to make factual statements regarding any of the events that occurred in Idaho, a false statement that Ashley Gouliard made false statements regarding Rebecca Schofield's involvement in the murder of the University of Idaho students that were not based in substantial truth, a false statement that Ashley Gouliard damaged Rebecca Schofield's reputation, a false statement that Ashley Gouliard undermined law enforcement efforts, and a false statement that Ashley Gouliard compounded the trauma the families were experiencing.
These should all be separate counts if you're actually drafting this properly, like a lawyer.
No, John, the comma does it all.
No, it really does not.
That was sarcastic.
It really doesn't. That's literally. Do you know how many times I've screamed at the screen compound question? This is compound allegations.
Yep.
Okay.
She used the Oxford comma.
It's not going to get better.
Patty, I was thinking that.
Well, I'll give her the credit that she did use the Oxford comma.
Buckle up. The false
Oh,
statements
God.
were spread by way of news media and social media to include ABC Universal News, The New York Post, CBS News, Time Magazine, CNN, 2020 Inside Edition, Good Morning America, Baller Alert, Washington Post, TMC, NBC News, MSN, Fox, Rolling Stone, Black Enterprise, Yahoo News, The Daily Nation Pakistan, ABC
No, not
7
the Daily
Chicago,
Nation
ABC
Pakistan.
7 News, ABC 8 News, The Houston Chronicle, Inside Edition, The Daily Beast, Insider.com, the Argonaut University of Idaho student newspaper, News Nation, the Independent UK, True Crime Network, Law and Crime, multiple YouTube channels, Apple
Maybe the
Podcasts,
appropriate venue would be
multiple
Pakistan.
TikTok pages, Twitter, Facebook user posts, Instagram user posts, Reddit user articles, and other media videos, MEA Worldwide, The One Issue Word, Sportscadia, Mama's Uncut, Find Law, Daily Mail, King 5 News, 4 News, Now, the Tab, Similar Worlds website, Fox 5 San Diego, NBC New York, 6 ABC, Pedestrian TV, Techno Trends, Perez Hilton's website, Oregon Live, the Associated Press, The Guardian, New York Daily News, Sandra Rose website, E-News, AOL, Moscow Pullman Daily News, the Sports Bureau website, Blavity News, Newsweek, 24/7 News around the world, The Hill, the U.S. Sun, Reason website, Pix 11 News, NBC Right Now, WREG News Channel 3, WREG News website, KTLA 5 News Channel, DC News Now, Ground News, Idaho Mountain Express, Tromag websites, and many more. The false statements on the frivolous lawsuit and press release initiated by Rebecca Schofield, attorney Wendy J. Olson, attorney Elijah M. Watkins, and attorney Corey M. Carone influenced and incited an online riot against Ashley Gouliard with over 20,000 negative comments across social media platforms, a massive amount of cyberbullying, death threats, and harassment to Ashley Gouliard, harassment to Ashley Gouliard's family and friends by way of messages from strangers, seeking to have Ashley Gouliard's son taken from her, to have her committed to a psychiatric facility, and to have her arrested.
Good. Now she knows what it's like when somebody says shit about you online. She knows exactly what she did to the professor now. Because that's what the professor received.
Yeah, Andrea, I think so.
You can't just lie on somebody, you know?
It's,
No, of course you can't. And before anyone says, and she made the argument, oh, free speech. Defamation is not free speech, period. It never was the freedom of speech. If you ever look at it, God,
She's receiving the same
I
type
want to actually give legal education, but my brain is so fried by this stupidity.
read the intellectual's comment.
No subject matter jurisdiction is claims that usually, therefore, the appropriate venue is the UN. Okay, the UN doesn't have a court, but she might argue that at this point. I mean, if she wants to argue the ICC, even though we didn't agree to that treaty either, they did say, what was it, Pakistan Daily News? I mean, maybe the case should be heard in Pakistan, and let's see how she fares there.
She won't. Very simple.
She wants it to be in Texas.
Yeah, well, that's probably not going to happen.
No, she's already defaulted.
And
She can
conceded by
one
filing.
hand and keep in the other.
Okay.
See which one fills up faster.
CCW said The Hague is a possibility. They're just used UN. No, they can't. We're not part of the International Criminal Court.
Nope.
Okay, here we go. The misleading press release, frivolous claim, and false statements about Ashley Gouliard that attorney Wendy J. Olson and Rebecca Schofield publicly published and encouraged further defamation against Ashley Gouliard. YouTube personality iNabber, who has over 933,000 subscribers, stated in a video he published titled "TikTok's Worst Psychic Ruined the Life of an Innocent Woman: The Idaho Murders," diagnosed Ashley Gouliard's mental state as nutty. That's not in the DSM-5, but okay. And falsely accused her of ruining an innocent woman's, assumingly Rebecca Schofield's life, and suggested Ashley Gouliard loses freedom of speech. MEA Worldwide, an independent digital media company that claims to be one of the world's fastest growing entertainment news publishers, with offices in the US and India, and that reaches hundreds of millions of people globally, wrote an article titled, "Who is Ashley Gouliard? Meet the internet's Taro Tubbs, who falsely accused Professor or Idaho murders." The article further defamed Ashley Gouliard as a liar who made demeaning, baseless claims that endangered Rebecca Schofield's life. The article portrays Rebecca Schofield as an innocent history professor. Dr. Grande, a YouTube personality with over 1.26 million subscribers, who also claims to be a licensed professional counselor of mental health, a licensed chemical dependency professional, and have a PhD in counselor education and supervision, published a video on YouTube titled "TikTok Psychic Uses Idaho Murders to Falsely Accuse Professor Ashley Gouliard Case Analysis," published in the description that Ashley Gouliard made false claims that she made about the 2022 Moscow, Idaho quadruple murder case, suggesting Ashley Gouliard doesn't put any thought into her videos, lacks critical thinking skills, makes bizarre statements, idiocy, and doesn't understand, suggesting mental health issues. Law and Crime Network published to a network of 4.29 million subscribers, suggesting Ashley Gouliard has mental health issues in a video titled "TikTok Sleuth Slams with Lawsuit from Idaho Professor Over Stern Murder Conspiracy." YouTuber Murky published a video on YouTube to his network of 376,000 subscribers titled "TikTok Psychic Lies About an Innocent Woman to Ruin Her Life." Ashley with WREG News published that Ashley Gouliard's actions are appalling in a news coverage regarding the lawsuit. Ashley with WREG News also stated she hoped to hear more about the Moscow Police Department following through on pressing criminal charges against cyber sleuths, but more specifically Ashley Gouliard. In the same video, another correspondent referred to Rebecca Schofield as an innocent person. There are plenty more defamatory videos posted to social media, the internet, podcasts, and television media, spreading the false statements Rebecca Schofield and attorney Wendy J. Olson made about Ashley Gouliard. Many of the media outlets wrote several articles, posted several YouTube videos, and aired several televised news coverages, spreading the false claims and statements that Rebecca Schofield and her attorney made about Ashley Gouliard to multi-millions of viewers across the United States and the world.
Wait, now she continues the paragraph numbering between sections? Sorry, I know that there's a lot to unpack even in those paragraphs, but it's not
But
even...
the numbering. The numbering is important.
It certainly is to John and the court.
Oh, God.
And anybody that's trying to actually make sense of the shit that you're saying.
Yep.
I mean, those blocks of text, one of the first things is if you write a block of text, a judge or more likely their clerk is just going to read past it.
Or not bother at all.
Yeah, there's that.
I like this comment.
Someone said Brooks was the worst city to defend himself. She said, "Hold my beer." You know what? Challenge accepted.
Brooks.
Definitely Brooks.
Counterclaim plaintiff Ashley Gouliard is an individual residing in Texas. She's an author, entrepreneur, and U.S. Army combat vet. Counterclaim defendant Rebecca Schofield is a public figure residing in Idaho. She's an associate professor and the chair of the history department at the University of Idaho in Moscow, Idaho. How does that make her a public figure?
It doesn't.
Ashley Gouliard is an author of what?
Oh, we can Google it. Let's look.
Well,
Because Lord knows if she writes like this, shit.
She's a professor in a history department, so I imagine she wrote some, like...
No. Ashley Gouliard, the psychic, is the author.
Oh, well, I don't care.
No. Schofield. The argument is you have to argue that Schofield is a public figure, and I imagine she probably wrote some scholarly articles, but other than that, I've never heard of her.
Either way, the threshold was
her doctoral thesis would be, or her dissertation would be public information.
Sure, it's probably out there. That doesn't make you a public figure.
Oh my God. Counterclaim defendant Wendy Olson. Counterclaim Wendy Olson is an attorney, former U.S. attorney for the District of Idaho, and partner in this law firm. The other counterclaim defendant is a trial attorney and partner. Defendant Corey is an attorney, former deputy attorney general for the state of Idaho, and an associate attorney here.
Yeah, those are the people you want to sue.
Oh yeah,
you went after the associate?
Mm-hmm.
Yes. She went after the attorneys.
Yes, and
No, I know,
the
but
former
she
deputy AG.
It's one thing to go after the principals. It's another to go after some random associate that happens to work for them.
Who also happened to be the AG previously.
Okay.
The guy probably just does like real estate stuff, and he just got dragged into this.
Yeah, right.
Jurisdictions proper under 28 U.S.C. 1332 because there's diversity of citizenship and the amount in controversy exceeds 75,000. Venues appropriate for the counterclaim because Rebecca Schofield's a resident of Idaho and the attorneys operate in Idaho.
Pause for 1 second on that one. She's arguing that venue was improper, like
that's yeah.
For the original claim.
And now she's saying that in the counterclaim venue is proper.
Don't make sense of it. There's no sense.
Does anyone have an issue with that?
Yes.
Okay.
Because you have to pick one. It's either proper for the claim, and you can file the counterclaim the same way, or it's improper for both. There is that is an entire dichotomy in and of itself.
I'm just I don't know how to. Okay.
I'm not sure where the hell it would actually. See, the thing is that the whole 9 yards went around the world like 3 or 4 times.
Okay, so hang on for 1 second. So intellectual iconoclasm has a really good point. Psyche is definitely not a public figure per her own internet clout chasing. Fair. She's then one that's hard to libel and not the subject of her own libel. So there is such a thing as the concept of people who are considered libel proof by their own actions. If you behave in such a ridiculous way that you don't have a reputation anymore, then you can't be libeled, because the whole point is that it is a damage to your reputation. If you don't have one, or if you have one that's so bad that nobody could possibly harm it, then you are considered libel proof.
You mean like this lady?
I think we're getting close.
Counterclaim plaintiff Ashley Gilliard incorporates by reference her responses to all prior paragraphs of this complaint, as if set forth in full herein. December 21st, 2022, Rebecca Schofield filed a frivolous, perjurious claim alleging that Ashley Gilliard defamed her with full knowledge that the statements Ashley Gilliard made about her are substantially true, with the intent to evade suspicion and to obstruct justice by preventing suspicion to avoid criminal investigation into her role in the murders.
Oh, shit.
On December 21st, the attorneys filed a perjurious claim alleging that Ashley Gilliard defamed Rebecca Schofield with full knowledge of the potential that the statements Ashley Gilliard made about Rebecca Schofield's role could be true. The claims against Ashley are in bad faith, lacking in fact, with the intent to harass, delay, and embarrass Ashley Gilliard and is frivolous pursuant to Nietzsche v. Williams.
I'll look it up while you keep reading.
Literally, John's face is my face right now. Oh my God.
The attorneys filed a perjurious claim to discredit Ashley Gilliard's statements about Rebecca Schofield's role in the murder of the 4 university students. The claim was filed with an intent to obstruct justice pursuant to this by preventing suspicion of Rebecca Schofield and to avoid criminal investigation. Rebecca and the attorney published false statements that Ashley Gilliard compounded the trauma that the family of the victims are experiencing. Wendy Olson published false statements that Ashley Gilliard re-victimized families of the slain students. The attorneys, a false statement. Ashley Gouliard decided to use community's pain for her online self
Go back to the Nietzsche case real quick. And I apologize if I'm injecting too much
You're good.
education. But all right, let me share this.
Hi, Blanche.
Let me make sure that. So she didn't even spell it right. It's 490 13 9, right? Yeah. So let me share this, and this is the syllabus of the case. It's the basic premise. I don't understand why this is relevant. If anything, it hurts her.
It's not. It's not relevant.
Well, if you want to pull it up.
She's playing with legal mumbo jumbo to try and make herself look smart. And all she's doing is make herself look that much more.
It's the exact
stupid.
opposite of what she wants to argue.
Exactly.
So, a provision in the federal informal pauperous statute authorizes courts to dismiss an informal pauperous claim if, among other things, the action is frivolous or malicious. This is brought through attorneys.
Yes.
So it's an entirely irrelevant case.
Exactly, Dazer.
Oh my God. All right, sorry. I just wanted to make that point. I'm slowly losing my mind. But no, the whole thing. So if you actually look at the case, one, she didn't spell it correctly. So let's start there. So you can dismiss a case from somebody filed in forma pauperis because it is blatantly frivolous. That is what that case speaks to.
However,
this was one brought by attorneys, and two, prima facie is not a bad argument and not a bad case. We have some problems.
Some.
If that's your citation, you've got some issues.
Again, some.
she's got issues counting. So, I mean, start there.
That's where you decided she had issues?
That's where I
Oh,
started.
honey, I decided she had issues on page 1.
Yeah, you're not a person.
I still want to do the research and
that's fine. I'm just saying.
For a fine audience, the case of it's Nietzsche versus Williams. It's Nietzke. So she didn't even spell it right. Basically stands for the whopping proposition that a federal court can dismiss a informa pauperis case against somebody, which I don't know what the relevance of that is here, but that's where we're at.
John, there is no relevance. It doesn't apply.
I know that. You know that. She clearly does not.
Well, she didn't ask either one of us, and I'm not a lawyer. And I can tell her, it don't apply. What are you doing?
All right. Sorry, I did not mean to derail your reading.
Good.
No.
But I just had to look that up and be like, I don't know that stands for what you think it stands for.
Hey, Loki, John's having a hard time with that spelling error.
I know.
Perhaps we need to help him.
Rebecca Schofield and attorney Wendy J. Olson published false statements that, let's see, we did this one. Wait, hold on. They published these statements with malice, without proof, and without regard to the truth or falsity of the statements, with the purpose of defaming and embarrassing Ashley Gouliard, evading suspicion and criminal investigation of Rebecca Schofield's role in the murder of the 4 university students. She wasn't
involved.
Wait, did she just admit that she herself is a public figure?
Yes.
Yes.
Okay.
I thought she tried to claim she was a public figure.
I'm sure she wants to be one here.
She's a public figure now. She's a public figure of ridicule.
Oh, it gets good. Yahoo
Yeah, I
News
see. We're only
quoted
halfway
Wendy.
there.
It does not help you as the litigant to admit you're a public figure. It is a much lower bar for defamation if you're not. And she basically just admitted it and plowed forward anyway.
Oh, just wait.
Yeah.
Yahoo News quoted Wendy
Very
Olson's statement.
stupid.
Miss Gouliard has continued to make false statements knowing they're false. Wendy Olson made a statement on Fox News Digital and was subsequently quoted on other media outlets saying, the statements Ashley Gouliard made about Professor Schofield are false, plain and simple. Attorney Wendy J. Olson told Fox News Digital in a statement, what's even worse is these untrue statements create safety issues for the professor and her family. The attorney published those false statements with malice, without regard to the truth or falsity of the statements, with the purpose of defaming and embarrassing Ashley Gouliard, evading suspicion and criminal investigation of Rebecca Schofield's role in the murders.
You said,
Okay. Again,
you said,
Wendy Olson and Rebecca published several false statements about Ashley Gouliard and disseminated them in a nationwide press release that was subsequently disseminated to other countries. The statements include, but are not limited to, a false statement that Ashley Gouliard decided to use the community's pain for self-promotion, a false statement Ashley Gouliard made false statements about Rebecca Schofield knowing they were false, a false statement that Ashley Gouliard had no basis to make factual statements regarding any of the events that occurred in Idaho, a false statement that Ashley Gouliard made false statements regarding Rebecca Schofield's involvement in the murder of the 4 University of Idaho students that were not based in substantial truth.
You lost me like 3 commas ago.
Hold on. A false statement that Ashley Gouliard damaged Rebecca Schofield's reputation, and a false statement that Ashley Gouliard undermined law enforcement's efforts. What?
Huh?
What?
What? We're getting another fucking list of news outlets. Okay.
But I just don't understand.
Neither does she.
The attorney Rebecca Schofield made statements about Ashley Gouliard. They were disseminated through media channels with multi-million viewers and readers, to include. I'm not reading them all again.
No, please don't. Please don't.
Just
the
the one
attorney
girl.
filed this claim in the wrong venue with the intention of obstructing justice for Ashley Gouliard by creating judicial conditions for Rebecca Schofield.
What?
Like you
John,
just
What does that paragraph even mean?
John, I'm gonna need you to explain that to me.
I don't know.
She just said the venue was fine.
She literally just said the venue is appropriate for this filing. And she's on default. What?
Next.
With the intention of obstructing justice for Gouliard by creating conditions for Rebecca Schofield. That's not a sentence.
She's so whatever.
That's not even a sentence. My high school English teacher would lose his fucking mind for that. You already admitted that a venue is appropriate.
I would like to point out.
Just did.
I'd like to point out that first-year law students are probably having seizures.
I'm gonna have a seizure. You
The-
literally admitted that venue is appropriate just above, and now you're arguing venue. And we're not even at the counterclaims yet.
Yeah, we don't even have any. Oh, here's the first counterclaim for relief. Just now.
Lovely. All right.
Getting close.
This isn't getting better. That's what I'm gathering.
No,
Rebecca
we're not.
Schofield,
But have
attorney
fun.
Wendy Olson, attorney Elijah Watkins, and attorney Corey M. Caron filed false statements against Ashley Gouliard, made false statements about her as a tactic to intimidate her from making statements about Rebecca. No, those are called cease and desist letters. They're not intimidation, but okay. Counterclaim plaintiff Ashley Gouliard incorporates by reference her responses to all prior paragraphs of the complaint as set forth herein. Attorney Wendy Olson made a statement on news media.
When you stopped at paragraph 9, or when you stopped at paragraph 14, or when you decided to actually, use paragraphs?
Okay. Well, then she complains that they made statements on news outlets knowing they were false. Same. Attorney Wendy Olson published the statements about Ashley Gouliard with actual malice. Ashley Gouliard strongly stated she believed her statements about Rebecca Schofield were true. She did not make any efforts to ask Ashley Gouliard whether she thought the statements she made about Rebecca Schofield were true or not. Attorney Wendy Olson cannot speak with certainty that the statements Ashley Gouliard made about Rebecca Schofield were false. Attorney Wendy Olson published the statements defaming Ashley Gouliard as statements of fact without regard to their falsity. Yeah, guys, I think she can, because here's the problem. She was in another state. Her own lawyers know what state she was in.
She's in a state of misunderstanding is what she's in.
Well, again, she doesn't have to. She doesn't have to.
Well, you didn't ask me if it was true. No, we know it's not true. She was in another state. We have proof of it. No, it's true. Truth is an absolute. Oh my God.
Truth is an absolute defense, and she actually provided she provided everything she could possibly have to prove that she was on the other, that she was completely off on the left coast. She had hotel receipts, car rental, etc. Like all of the things. Oh, and her flight ticket when she got there and when she got back.
Well, again, which are you going to believe? Your client who is a published professor or some random psychic out in Texas? I'm going to go with my client on that one.
Yeah.
Attorney Wendy
Yeah, well,
Olson.
randos are a thing, John.
Oh, yeah. Attorney Wendy Olson published a false defamatory statement about Ashley Gouliard in a strategic attack to prevent Rebecca Schofield from being suspected or investigated for the murder of the students. How many times are you going to defame this woman in one?
Stop!
Shut the fuck up.
So
get an attorney.
Her argument is she thought what she was saying was true about the professor. So the psychic thinks what she's saying is true. So it's not malice. So it's not defamation. So it was for public safety. She's so full of it.
Yeah, she's absolutely wrong because our professor, she's not a public person.
Well, not even that. She's wrong because it's not true. But she thinks by saying I thought it was true makes it not defamatory.
Well, but here's the thing is that would be the case if she were a public figure and she genuinely thought that it was true.
But she's not a public figure. Yeah.
But she's not a public figure. You made her a public figure by attacking her.
And even then, most people have forgotten about her now.
Right. You can't drag someone into public figure status by attacking them. I mean, we saw this in the Nick Sandman case.
Oh, just hold on for a minute.
Oh, are we not done?
No.
Oh, God. I'm so sick and tired of people telling me that it gets worse.
Only 9 pages left to go.
Defamation to a defendant's character in the news media is not legal remedy for alleged defamation to a plaintiff. Attorney Wendy Olson, with over 16 years' experience as a U.S. attorney,
what does that sentence even mean?
Published those defamatory statements to the news media about Ashley Gouliard with full knowledge they were defamatory. Making public defamatory statements about a defendant and spreading false information on the news media about a defendant is not an attorney duty prescribed by law that is protected by immunity or absolute privilege. Attorney Wendy Olson made those statements with malice outside the setting of litigation with the sole purpose of defaming, harassing, discrediting, and intimidating Ashley Gouliard nationally and internationally.
What?
So she called her out on her bullshit, and Ashley didn't like it. Got it.
Pretty much.
All right.
You want me to scroll back up for you?
No, I just go back to that first sentence and explain to me what that means.
I don't know. You explained it to me, or you went to law school, not me.
Defamation to a defendant's character in the news media is not a legal remedy for alleged defamation to a plaintiff. So defamation doesn't cure defamation?
Basically.
That's like one of the stupidest sentences I've ever read.
I agree.
I just like how it now means attorney-client privilege doesn't count according to her.
Uh-huh.
Well, privilege is a different issue than this, but
She throws that into it.
yeah, she does.
Now,
Making public defamatory statements.
I have a hypothesis here before we continue any further into
Wait,
this.
hold on. I want to hear John sing about privilege first, and then you can give the hypothesis.
So I was going to say that privilege is purely comments or conversations between the attorney and their client and keeping them silent. You cannot force them into court. But here's the sentence: making public defamatory statements about a defendant and spreading false information on news media about a defendant is not an attorney duty prescribed by law and protected by immunity or absolute privilege. No, you're right. It's not. But so the fuck what?
But what does it have to do with this?
What's the relevance?
Rebecca Schofield made statements, initiated the press release, and initiated
on,
the
hang on.
filing of the lawsuit, claiming the statements Ashley Gouliard made were false with full knowledge and experience that the statements Ashley Gouliard were true. Ashley Gouliard's reputation was severely damaged across the U.S. and social media due to false statements spread by Rebecca Schofield and attorney Wendy Olson. Okay, go for it, Krakow.
Wait, okay. So here's my hypothesis. This lady was late responding, like completely late responding. And she's filed this whole damn thing pro se. What do you want
Instead of responding.
What do you want to bet that she cooked this up and then went around every lawyer she could freaking find, and they all said, no, we're not going to do that. And that's what results in this.
All right, so before you start reading this second counterclaim, I would like to read to you 28 USC 4101.
Okay.
Because this is just compounding the stupid. 28 USC Code 1401, stockholders' derivative action. Any action by a stockholder on behalf of his corporation may be prosecuted in any judicial district where the corporation might have sued the same defendants. So just so we know, this is the citation that they're making before they go into this second counterclaim.
What? How did...
I think she meant 18, but even that one's not much more helpful to her.
Well, what?
So apparently this is a stockholder claim, and this is establishing venue and jurisdiction.
Are you having fun, Iris? I
The
promise
difference
you're fun.
between 18 USC and 28 USC. Seriously.
She wrote 28 USC, which is, and the reason why I immediately had to look that up is because that essentially covers secured transactions.
She'd
Hey,
like
J.
a
Michael.
secure transaction.
Yeah, it's securities law that she's literally citing. She doesn't know that she's doing that, but that's what she's doing.
No, you didn't break the squirrel. The squirrel is just kind of sideways at the moment. He will sort himself out eventually.
But yes, that is 28 U.S. Code 4101. Oh, hang on. Maybe I have that. I actually have that backwards. Give me a second.
I like that. Statements made by attorney Wendy.
Hold on. Well, you look, I'm going to read.
I might have been
Hi,
mistaken.
Todd.
Oh, that's literally just the that's.
Hey, it's J. Michael. He turned up.
Yep.
All right, I apologize. I misspoke.
Okay.
I did that wrong. 4101 is the definition section of the defamation statutes. And literally all it says is the term defamation means any action or other proceeding for defamation, libel, slander, or a similar claim alleging that forms of speech or false, etc. So I was mistaken. It's not as stupid as I thought it was.
No,
Still,
yes, it is. It's just in a different way.
It's still stupid.
Yep.
It's still stupid. It's just not as stupid as I quite thought it was.
Second
So I'm
counterclaim.
gonna. I'm
So it's
going.
stupid to the 2nd degree instead of the 10th. Got it.
Yeah.
Well, I'm gonna plead error. That was my fault. I mixed up the numbers. That was my bad.
your
The
plea
sec-
has been accepted, counselor.
Okay.
John, have you ever watched NCIS?
Of course I have.
Okay, Gibbs has a rule. Don't apologize.
Yeah, well,
I'm gonna pin that to my chat.
fair enough.
Counterclaim. Counterclaim plaintiff Ashley Gouliard incorporates by reference responses to all prior paragraphs of his complaint if set forth in full herein. Attorney Wendy J. Olson made a false defamatory statement against Ashley Gouliard in several national news media televised articles on the World Wide Web that Ashley Gouliard undermines the law enforcement efforts to find the people responsible in order to provide answers to the families and the public. Wendy J. Olson made that false defamatory statement about Ashley Gouliard, knowing it was false and regardless of its falsity or not. The truth is the inverse. Ashley Gouliard was trying to help the investigation as requested by the Moscow police. On November 23rd, 2022, the Moscow Police Department made a public statement. Tips. Detectives are looking for context to the events and people involved in these murders. Anybody who observed notable behaviors, video surveillance, or can provide relevant information is asked to call the tip line or email or upload digital media. Ashley Gouliard's
Time out.
videos and
Stop.
statements regarding
Stop.
the murder of the
Stop.
four students and
Stop.
potential murderers were
No,
made after
no,
this
stop.
statement.
Stop. Stop. Stop.
Wait.
There is no way that lady in Texas had any access to any of the information that the police were looking for in Idaho.
But she's
It
psychic.
just,
See,
you know
here's the
what?
thing.
But
I
So
want
is
to
my
know
kitty
how that.
cat Fanny, but I don't believe her either.
Hello.
But the 8-ball said it was true.
Nobody
Oh my
cares.
God.
Now, here's the thing. She says that is a request from the Moscow Police Department to her. This was
Yes.
a general request for, hi, does anybody know what the hell actually went on here?
Yeah.
Okay, that is not a request that made of them. It was made by them to her. She has no business being anywhere near this, and that will not make a defense in any way, shape, or form. In fact, she calls in that tip, and they have to expend resources, time, effort, money, etc., to go out to call this lady or go visit this lady, even worse, to say, okay, how does this work?
Well, and that's one of the problems when it comes to general tip lines is you get a ton of people that send in utterly irrelevant information, but you have to parse through it. And that's why general tip lines are not particularly effective investigative tools in my understanding.
And from my understanding, they're also rarely used for exactly that reason.
Yeah.
Yes, correct.
That's like a last-ditch effort. But even then, they would have called her, not her posted on TikTok. She should have just called the police department if she really thought that. No, she decided to make money off of it, defame this poor professor, and just make her world turn upside down.
Yup.
That's a much better argument than I just
And
made.
just
That's a much
about
better
get
point than I made.
and still just about get her fired.
I would like to point out that all of this could have been fixed by a well-placed chancla.
All of this could have been fixed by
She's missing all the screws. What do you mean some? Just all of them. Just all.
Iris, well-placed chanclas could fix this.
Agreed.
Oh yeah.
So could duct tape.
A well-placed chancla, she wouldn't have spoken online ever again. On December 7, 2022, the Moscow Police Department made a public statement seeking more information. Your information, whether you believe it's significant or not, might be the piece of the puzzle that helps the investigators solve the murders. Ashley Gouliard's videos and statements regarding the murder of the four students' potential murderers were made to help provide information. On December 27, 2022, the Moscow Police Department made a public statement saying, Investigators believe someone has information that has contacts to what occurred on the night of the murders and continue requesting additional pictures, video, and social media content. After the lawsuit was filed, law enforcement did not make statements to Ashley Gouliard or otherwise Ashley Gouliard undermined their efforts. The video and statements that Ashley Gouliard made regarding the murder of the 4 students was to help law enforcement get answers, to find the murderers that could be legally tried for their alleged crimes, to provide answers and potential relief to the public and the victims' families.
No, you're talking
you
about
remember
wasting the public
Steve?
money.
Yeah.
Woman.
Do we remember Steve? Let's talk about Steve.
Yes, let's
And
talk about
Steve saying too much
and getting cut out
and
of
getting
the
cut
update
off
loop
of information.
as a result.
You know, Ashley needs to be more like Steve and shut up.
Attorney Wendy J. Olson provided those false defamatory statements about Ashley Gouliard with the knowledge of the statements from the Moscow Police Department requesting more information. Ashley Wendy J. Olson published false defamatory statements about Ashley Gouliard to a plethora of news outlets with malice, knowing they were false with the intent to prevent Ashley Gouliard from providing more information about Rebecca Schofield to the police department and to the public. Ma'am, you are not the main character in this.
Whatever.
Yeah, no, she's the hero. She's the hero of her own story. And did I hear this correctly? That actually managed to get herself arrested for this shit?
I don't know, but I would like to point out that you are not the main character, woman.
No, she's not.
I think she is. They were speaking directly to me. You sound like a paranoid schizophrenic. The people in the TV were talking directly to me. No, bitch, they weren't.
Nope.
Attorney Wendy J. Olson's false defamatory statements about Ashley Gouliard incited further news coverage spreading the defamation, incited online rage on social media further defaming Ashley Gouliard's character, incited the spread of false statements that Ashley Gouliard was insane, has mental health issues, suffers from psychosis, has schizophrenia, posting videos for clout, harming the victims' families, insane, causing harm to Rebecca Schofield and her family, and more. Many people, to include people who were following Ashley Gouliard on social media, believe those statements without any thought or research into the truth or falsity.
I wonder why. He
I
listed insane twice. I want to know what any of that is false.
How many times is this woman going to defame this poor professor?
Um,
And this
Or her
poor
attorney.
attorney? This poor attorney is regretting her life choices.
all of
No, this poor attorney is rubbing her hands together, going, I'm gonna get a payday out of this bitch.
How much money do you think she actually has that you can collect on?
Nah,
It doesn't matter because that shit won't go away.
she's judgment proof. She doesn't have anything. Maybe royalties from TikTok. That's gonna be taken down soon.
Yeah, even if it doesn't go, there's no money in this.
Attorney Wendy Olson's defamatory statements about Ashley Gouliard stifled her work performance, damaged her reputation, and resulted in a loss of service and revenue. Prior to the allegations, Ashley Gouliard was helping a mother get details regarding the R-word and essay of her 6-year-old daughter by a close family member, helping a sister get details regarding the unsolved murder of her brother, helping a woman decide on a course of action to get justice for an essay in her past, helping a daughter get details on the murder of her father, helping a wife perceive the ramifications of a divorce or continued marriage, and more. After the defamatory allegations, Ashley Gouliard was unable to focus on serving others and received less inquiries due to the damage to reputation. If the truth was told, Ashley Gouliard would have been able to serve more people, to include helping to solve the murders of Takeoff, Shanquella Robinson, Tiffany Valente, Kevin Samuels, and Tamla Horsford.
Time.
As the
Hold on, time
psychic,
out.
Yeah.
Time out. Okay, first off, I want to know where she comes up with any of that information, close family member, etc. Is she a therapist, a children's
yeah,
therapist?
CCW's right. Citation needed.
Yes, I agree. Citation needed. Citation needed because this lady, no, nuts.
Weathermen are more accurate than she is.
1, 2,
Some pills are needed, not just
3,
citations.
4,
I was
Iris, I
thinking,
promised you it would be fun.
Iris,
I promised you it would be fun.
Wow, just holy crap. Yeah, I think it's actually. I think Mayor Wrench, you may actually be up. You are probably onto something. But
See, aren't you guys
There you
glad I
go.
had insomnia and was reading random shit?
I was going to say, can we please reopen the asylums at some point?
it needs honestly it needs doing. No, I don't think lithium is gonna help in this case.
Iris, just chuck her over the border into like Laredo.
No, she won't come back if she goes over the border.
That's the point.
Can
That is referred to
That's
as
my
the I
point.
love me jacket, not the hug yourself jacket.
That's my point.
can
Give
we
her to a
please
cartel member or
reopen-
something. I don't know.
I've worked psych nursing. I know what that's called.
Can we please reopen Creedmoor and Pilgrim State in New York, and we'll at least have somewhere to put people.
Well, they could with some ease get her parked at Western State up here. Unfortunately, that's probably not going to end as well as she thinks it will. There should be similar psychiatric hospitals in other places in the United States, including Texas. Iris may be able to suggest something a little more local to her.
Okay. Press on. Attendee Wendy Olson's defamatory allegation of the
Debbie,
media about
I know,
Ashley
right?
Gilliard. I know. Undermining law enforcement efforts was made without evidence, with malice, and without regard to its falsity or not. It was made for publicity purposes to defame Ashley Gilliard's character, and so the information she provided about Rebecca Schofield is not taken seriously by the public. Making public defamatory statements against a defendant and spreading false information on the news media about the defendant is not an attorney duty prescribed by law that's protected by immunity or absolute privilege. Attorney
This
Wendy
is-
Olson made these statements with malice outside the setting of litigation.
Citation needed.
That was a copy paste from the previous paragraph.
Providing a public statement on behalf of her client, Rebecca Schofield's a lawyer. Providing a public statement on behalf of her client, Rebecca Schofield is a lawyerly duty prescribed by law. Defaming the defendant, Ashley Gilliard, with malice, disseminating false statements to the national and international public is not Attorney Wendy Olson's duties prescribed by law. Attorney Wendy Olson's fully accountable for the defamation.
Wait, no, let's go back to that paragraph for a second, just because the stupid of the phrasing.
Go for it, 'cause
Providing
I
a
was
public-
damn confused.
Providing a public statement on behalf of her clients is a lawyerly duty prescribed by law. Defaming the defendant with malice, disseminating false statements to the national and international public is not the duty prescribed by law. That's basically what she's saying. Okay, but here's the issue. You have not provided any evidence that it's false or in any way defamatory. Like, you can't just assert these things and presume that's the way that it works. You can't just, in a complaint or a counterclaim, you can't just assert things. You need to present some modicum of evidence to overcome a motion to dismiss. And this counterclaim is getting dismissed immediately. I almost guarantee you.
I'm not even sure. The judge may, if I was the judge in that situation, I would go, yeah, dismissed. We're not even going to bother asking the other attorney.
Sometimes the courts can do that to a sponte.
Before I forget, there's 29 of you in here. Please do the YouTube things like, subscribe, comment. It all helps in the algorithm. And if you are enjoying our tormenting of J. Robine Law, Croc will put up a PayPal link for him, and you can support his psych bills because of the things I put him through. And everybody that's involved, links and everything will be in the channel for all of the things and all of the fun.
Okay, there's one for Loki. Since she's telling me to put mine in there, I will most certainly do that.
Yes.
Because
While you're doing that, I'm going to read the next one.
I'm going to need some brain bleach here.
Yes,
Serious.
everybody will. But hold on, I'm going to read the next one while you do that.
Yes, and the second monitor fund because that one over there is kind of wrecked.
Uh-huh. Hold on.
I
Where'd
put
I
another
go?
monitor about this time.
How about we get you all a camera fund?
That would work too. There's actually, funnily enough, there's a camera on my Amazon wish list. You can go find it. It's not that
Okay.
hard.
Including defamatory statements made by attorneys outside of a legal proceeding in immunity and absolute privilege would unreasonably shield attorneys from liability for defamatory statements that would otherwise be actionable if uttered by anyone other than an attorney. Allowing such actions would permit attorneys to defend their clients by any means without repercussion for illegal or punishable actions. The intent of attorney immunity is to protect attorneys from suit when they are in good faith performing duties on behalf of or in defense of their client during legal proceedings and duties. Actions committed in bad faith by attorneys that are illegal or that are not permitted by civil or criminal law is not within the scope of attorney immunity. And Attorney Wendy Olson's in bad faith and malice made defamatory statements to a worldwide audience about defendant Ashley Gouliard. This has caused hardship and severe damage. What about what you did to this poor professor and her family, bitch?
She just says that they're not defamatory because she thought that they were true. She just doubles down every time with saying that I thought this was true. I know this to be true. So everything that they're telling, every time they say that I lied or is false, so they're defaming me.
It was true.
That's just wow.
But we have proof that the lady was like in another state, but that's not enough.
It's just, how do they say?
Everybody get their tinfoil out.
Just wow.
We're all going to need
Ain't
like
that the
tinfoil
truth?
hats at this rate.
All right. Yeah, give me a second. Give me a second on the channel link.
Yeah. Counterclaim plaintiff Ashley Gouliard incorporates by reference her responses to all prior paragraphs. Rebecca Schofield and Attorney Olson published false statements that Ashley Gouliard compounded the trauma that the families of the victims are experiencing.
Sorry, can I ask you to pause 1 second?
Mm-hmm.
Look at the actual caption of this section.
Defamation 28 U.S. Code 4101 press releases statements and lawsuit alleging that Ashley Gouliard compounded the trauma that the families of the victims are experiencing and re-victimized families of the slain students.
You re-victimize the families of the slain students, you idiot. You absolute moron.
And now you're doing it again by filing this.
You're the one that did that. It wasn't the press releases saying that you're a moron and we don't care what you have to say.
Confession through projection. Remember, John?
Yeah.
Because that's what's happening here.
Tell me I'm wrong. All right, sorry. I just needed to point that out.
You're good. The attorney published false statements that Ashley Gouliard compounded the trauma that the families of the victims are experiencing. Wendy Olson published false statements that Ashley Gouliard re-victimized the families of the slain students. Rebecca Schofield and Wendy J. Olson published those false statements without proof and without regard to the truth or falsity of the statement, with the sole purpose of defaming, harassing, intimidating, embarrassing Ashley Gouliard. The truth is the inverse. Ashley Gouliard worked tirelessly, passionately, and without pay to help victims' families get justice. The false statements that Rebecca Schofield and the attorney published about her caused a mass shift in public opinion. Instead of acknowledging Ashley Gouliard for her help, she was ridiculed, harassed, shamed, humiliated, and falsely accused of lying.
But hey, John, but she keeps numbering, so it's good. The numbering.
She has at least kept the numbering. I will give you that.
I have questions.
I need another
You have
drink.
questions.
I have questions.
I have whiskey.
Oh, how is any of that shit relevant? Whether or not you're working tirelessly, passionately, etc.
I don't know how that counts at all.
What does that do? What does that have to do with the price of tea on fracking Mars? I have questions.
Yeah, that doesn't
you
actually answer
just
anything.
because you think the bullshit you're peddling is true doesn't make it that way.
And they're
Does
going
anybody
back
have
to
anything to
Nietzsche
cure a
versus
headache?
Williams. Yay!
What?
This is literally the court case by which I would dismiss your entire complaint.
What are we talking about?
We'll get there.
Hold on. The CCW is asked the valid question. Pretty sure that's what I'm pretty sure that's what she's trying to pull here, but I don't know.
I mean, are we on the playground or are we in a federal district court?
We're supposed to be in a federal district court, but I think I think this is actually. I think we might actually be looking at the sand pit, near the kiddie pool.
Now, notice that her fourth counterclaim for relief, which is not how you phrase anything, but whatever. I'll let that slide.
This one has fraud.
John, before you comment,
No, it does not. My professional obligations are not to denigrate another attorney. She is not one. She's an idiot.
And that's, oh, by the way, folks, you do not have a right to be free for being, you do not have a right of freedom against insult. Insults are offense.
Unless it's fighting words. I mean, you know.
okay.
And we're back to Nietzsche versus Williams, which is literally the case that I would use to have her complaint dismissed. But
Okay, so we're gonna go with
Okay, before
our
that,
fourth counterclaim.
explain Nietzsche versus Williams. I have to know.
all right.
Let me do this first, and then he can explain it.
Okay.
Yeah.
Counterclaim plaintiff Ashley Gilliard incorporates by reference her responses to all prior paragraphs of this complaint as if set forth herein. Rebecca Schofield, attorney Wendy J. Olson, attorney Elijah
You
M.
spelled it
Watkins,
right
and
this
attorney
time.
Corey M. Carone filed false claims against Ashley Gilliard. Rebecca Schofield and attorney Wendy J. Olson
She cited.
made false statements about Ashley Gilliard in press releases as a tactic to intimidate Ashley Gilliard from her testimony on social media and to the FBI tip line about Rebecca Schofield's alleged roles in the murder of the four students. According to FROE Rule 611, mode and order of examining witnesses and presenting evidence,
I do.
controlled by the court proposes the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth, avoid wasting time, and protect witnesses from harassment or undue embarrassment. Anybody who provides relevant information to police investigators or potential witnesses should be protected from harassment or undue embarrassment in and out of court. The press release and filing of false claims is a violation of Rule 611 because it prevents witnesses from providing information that could be helpful to investigators for fear of being sued and for fear of being nationally embarrassed and defamed. Ashley
Wait.
Gilliard
What's
no
that
longer
ROE?
feels protected enough to use her knowledge to help with any more cases, including the case of the murder of the 4 University of Idaho students, for fear of more
What a
harassment
stupid
knowledge?
argument.
and frivolous claims against her. There you go. Okay. Sorry.
Okay,
That's
can you
probably
scroll
a
back
good
up
idea.
just a hair? Can you scroll up just a hair?
Thank
Just a little
God
bit.
she's not using her knowledge. Can you imagine?
Keep going.
Yeah, no, you're good.
No,
Rule
one more.
611 is literally just
What is
order of
FROE?
examining witnesses and presenting evidence in trial.
What's
It
a
has
fraud?
nothing to do with anything that she's saying. We're pre-trial.
And here's my other question. This is civil. Isn't that a criminal thing?
The federal rules of evidence? Is that what that's supposed to be?
believe-
Yes.
No, it's federal rules of evidence. So it applies, generally speaking, this is to trial, but you can interview whoever you want in whatever order you want. The question is do you have a certain degree of propriety as it relates to present the evidence to the jury?
Okay, so this Williams case, what is it, John?
Do we want to do this?
You
Just give us
I'm
a
not
thumbnail right
against-
now. We'll go into detail
You're
later.
allowed to educate. I'm not against it.
All right. Let me pull up the syllabus and we'll just read it together.
So you want me to read the last little bit, like some of this while you're looking, or do you have it?
No, I got it up.
Okay,
You want to put it into the stream?
you can do it.
I'll
Croc
do
can
it.
do it.
I gotcha. There we go.
All right. A provision in the federal informal pauperous statute authorizes courts to dismiss as informal pauperous claim if, inter alia, the action is frivolous or malicious,
Respondent Williams, a prison inmate, filed a petition to proceed in forma pauperis and a complaint under 1983 in the district court charging that the prison officials had violated his Eighth Amendment rights by denying him medical treatment for his 14th Amendment due process rights by transferring him without hearing to a less desirable cell house when he refused to continue working because of his medical condition. The district court dismissed the complaint sua sponte as frivolous on the grounds that Williams had failed to state a claim upon which relief could be granted under Federal Rule Civil Procedure 12b-6. The Court of Appeals, holding the district court, had wrongly equated the standard for failure to state a claim under 12b-6 with the more lenient standard for frivolousness under 1915, which permits dismissal only if a petitioner cannot make any rational argument in law or fact entitling him to relief, affirmed the dismissal of the 14th Amendment claim on the ground that the prisoner clearly had no constitutionally protected liberty or property interest in being incarcerated in a particular institution or wing. However, the court reversed the dismissal of the Eighth Amendment claim as to 2 of the 5 defendants, declaring itself unable to state with certainty what Williams was unable to make any rational argument to claim. Held, a complaint filed in forma pauperis is not automatically frivolous within the meaning of 1915d because it fails to state a claim under Rule 12b-6. The 2 standards were devised to serve distinctive goals and separate functions. Under 12b-6, which is 12b-6 is failure to state a claim. Failure to state a claim standard, which is designed to streamline litigation by dispensing with needless discovery and fact-finding. A court may dismiss a claim on dispositive issue of law, whereas 1915d's frivolousness standard, which is intended to discourage baseless lawsuits, dismissal is only proper if legal theory, as in that 14th Amendment claim, or the factual contentions lack an arguable basis. Common ground between the 2 standards does not mean that one invariably encompasses the other, since where a complaint raises an arguable question of law, which the district court ultimately finds is correctly resolved against the plaintiff, dismissal on 12b-6 grounds is appropriate, but dismissal on the basis of frivolousness is not. Marshall was a weird court.
Why on earth did she bring this one up?
She cites it every time because she doesn't want her shit getting dismissed.
It's going to be.
The conclusion flows from 1915d's role of replicating the function of screening out inarguable claims from arguably meritorious ones played out in a realm of paid cases by financial considerations. Moreover, it accords with the understanding articulated in other areas that not all successful claims are frivolous. It is also unsuccessful claims, It is also consonant with Congress's goal in enacting the informal pauperis statute of assuring equality of consideration for all litigants. To conflate these standards would deny indigent plaintiffs the practical protections of Rule 12b-6, notice in which they intend to amend the complaint before the motion is ruled on, when not provided for complaints are dismissed sua sponte. So, because I read that pretty quickly, let me break it down. We have 2 statutes in this country that are relevant in that particular case. Okay. So we have the 1915d and we have 12b-6. So 12b-6 is dismissal for failure to state a claim. And the general rules as it relates to that is essentially if there is not a genuine argument in law, or if there is not a claim that the court can actually remedy, it's tossed. Period. Now, what Congress did, and Marshall, in my opinion, was actually wrong in this case, because 1915D says that the officers of the court shall issue and serve all process and perform all duties in such cases. Witness shall attend as in other cases, and the same remedies shall be available as provided for by law in other cases. So Marshall separating the potential remedies, to me, was actually a mistake of law. However, this is the state of the law, and this is why she keeps citing this case, because it is like the person clinging to a ledge, trying not to get her case dismissed outright, because she clearly is not stating a case on her counterclaim.
Off to 43. All of the attorneys used this tactic to intimidate Ashley Gouliard from her testimony on social media and to the FBI tip line about Rebecca Schofield's alleged role in the murder of the students, according to FRE. Again, controlled by the court. Yeah, the same thing. We just repeated.
You might want to put
hold on.
your screen back up.
Hold on.
I hijacked it for a minute.
Sorry.
We good?
Go
We're
for
good.
it.
Attorney Wendy J. Olson, Attorney Watkins, and Attorney Carone filed this claim in the wrong venue with the intention of obstructing justice for Ashley Gouliard by creating judicial conditions unfavorable for Rebecca Schofield and prejudice for Ashley Gouliard. The attorneys have over 40 years' experience as U.S. attorneys. They have enough knowledge and experience to properly interpret 28 U.S.C. 1391 to choose the correct venue. The events giving rise to civil claims for defamation took place on Ashley Gouliard's social media channel on the internet and Ashley Gouliard's location. There's no district in which this action may be otherwise brought except the U.S. District Court for the Southern District of Texas. The attorneys...
Why was this not raised in the venue section?
The attorneys, with knowledge that she's a resident of Houston, Texas, filed this claim in the wrong venue, the U.S. District Court for the District of Idaho, with the malicious intent to create unfair judicial circumstances. Well, then maybe you shouldn't have filed a counterclaim in that same court.
Yeah, that kind of hurts your argument there. And by the way, why is that a counterclaim for relief? That should be part of your venue and jurisdiction section.
You seem surprised that she put it there.
That's not actually a counterclaim.
And she already agreed to venue.
I know.
Mm-hmm.
Sorry, I just... Okay.
The Texas judges won't like her either, so it doesn't matter where she puts it.
Oh, the Texas judges will love her. And I mean that with all the, I would have popcorn. Mike needs to live stream that. I would have popcorn and beer.
I'm literally
with all of the venomous
What'd you say?
I'm having popcorn right now, just watching this, just having fun.
Oh, I was saying that you mean that with all the venomous sarcasm you can muster.
And then some.
Yep.
Let's go. Oh, we're IIED. John, IIED.
You've got to be kidding me.
IIED, John.
Oh, cheers. No.
No, please don't try this.
Counterclaim
did it
plaintiff
anyway.
Ashley Gouliard incorporates by reference everything. The filing of frivolous claims against her by the attorneys and the person, and the mass disseminated press release with false statements about Ashley Gouliard encouraged mass harassment against her pursuant to Idaho statute. Ashley Gouliard received harassing phone calls, emails, text messages, comments and messages on Instagram, messages and comments on Facebook, messages and comments on TikTok, messages and comments on YouTube, messages on Ashley Gouliard's website, her website, www.ashisgod.com, threatening to inflict harm against her, signing her up for porn websites, expressing wishes she'd kill herself, maliciously misdiagnosing her as insane, maliciously misdiagnosing her as crazy, maliciously misdiagnosing her with schizophrenia, maliciously misdiagnosing her with psychosis, expressing the desire to have her arrested for her allegations about Rebecca Schofield, and sending her indecent video parts and dick pics.
What?
Eh?
What did
Are
she
you-
want?
Are you suggesting the professor and the lawyers are the ones doing this?
What?
Yeah. That
Wait,
is
were
what
they
they're saying.
good?
I kind of doubt that.
That's
I
why
have, I have questions about
She
that
would-
allegation.
she would have nothing. She would have nothing to go for if this weren't it.
Wait, but it says videos of body parts to include that. So in other words, she got foot pics as well, I think.
Okay, I mean, I'm not doubting that occurred, but I don't think that they intentionally were. I very much doubt that either the counterclaim defendant or her attorneys were actively encouraging people to do that.
No, because they're not stupid.
I'm sorry. This is like the best thing. They sent her dick pics. What?
I
Why would anybody do? Okay, people. There's a rule that every man should remember. Beyond reason. Stick to this one, guys. You will survive a lot longer in this world. Never stick your dick in crazy, and certainly don't show it to it. And certainly don't
yeah,
show it
there's
to them.
that.
I'm just saying.
Never ever do this. Take it from the guy that was stupid once.
I
Yeah.
Hey,
Oh,
Coco, I'm so happy that in my day we didn't have this many cameras.
know.
Ooh,
Oh wait. Oh wait.
Mayor Wrench, Mayor McNome, thou shalt share the peeps.
The filing of frivolous claims against her by Rebecca Schofield and the attorneys and the mass disseminated press release caused harassment against Ashley pursuant to Idaho statute by the initiation of a petition to have her arrested that was signed by more than 10,000 people on change.org.
And I would like to just stop real quick because she keeps citing this. 18 USC 1514 is a criminal federal statute that makes it illegal to intimidate a federal witness. So I don't know what the fuck she's talking about in a civil complaint in Idaho.
Here's another fun one for you. You say she apparently has not because she provides no evidence.
Well, obviously she
that
doesn't have it.
any of this that anything other than some moron rando on the internet put together that change.org position.
Hold on.
Petition. Besides which, those things are not legally binding in any way, shape, or
Hey,
fashion.
Croc,
What?
just hold on 1 second because you might as well just add this to the rant.
Oh God.
The filing of the claims instigated harassment pursuant to the statute against her by sending messages to her family and friends seeking to have her committed and held in a psychiatric facility and taking her personal address to have her arrested by Idaho law enforcement. The filing of the frivolous claims against Ashley by Rebecca and the attorneys and the press release caused her substantial emotional distress, mental distress, suffering, or anguish, including depression, shame, humiliation, shock, embarrassment, grief, and anxiety and fear. Ashley Gouliard suffered a loss of enjoyment of life. Ashley Gouliard typically travels on New Year's Eve, as she did in 2021. Instead, NYU 2022, she had to stay inside for fear of her life, arguments, and embarrassment. Ashley Gouliard suffered mental anguish due to potential harm caused by the continued threats to kill her or hopes she'd die. She suffered mental anguish, depression, shame, humiliation, shock, embarrassment, grief, anxiety, and fear from false statements about her that were widely disseminated nationally on news media and social media, causing her to stay home on New Year's Eve and isolate herself more than normal. The filing
Aww.
of these claims
Poor baby.
influenced a mass amount of news media and social media articles, videos that further disseminated the false statements, causing her to be publicly ridiculed, humiliated, shamed, and threatened.
Wait, hang on. Sorry. So her theory, and again, she's citing the wrong statute, clearly, because she's talking about a witness intimidation statute, which she's not. So because she didn't go out on New Year's Eve, people made more comments about how she's a lunatic.
Mm-mm.
No,
Is
because people made comments that she's a lunatic, she was too scared. She was too scared to go out to leave her house on New Year's Eve.
I think she argued that there was kind of a loop on that one.
She needed to stay home to get all those pictures.
Oh God. Okay.
Look, she started.
Finally, we're at the ad damnum, which
Okay.
prayer for relief. In Latin, it's ad damnum.
Wait, this is great.
Hey, John, number 1.
Mass press release with a statement that Ashley Gouliard
Oh my God!
approved
They reset
to
the
every
fucking
news
paragraph.
outlet that this lawsuit was covered, and to social media outlets, Facebook, Twitter, TikTok, Instagram, Reddit, and all the others that it was covered on, correcting the false claims made against her. Mass press release in every news outlet this lawsuit was covered, and to social media outlets and others, with an apology to her that she approves for all accusations. Compensatory and punitive damages in an amount determined by the judge, attorney and court fees that may arise now or in the future for any action related to the case, for
What
judgment
attorney's
dismissing the
fees? You're
plaintiff's
pro se.
claims for improper venue pursuant to FRCP Rule 12b3 with prejudice, for summary judgment for the counterclaim, pre-judgment and post-judgment interest, and all such relief as the court deems just and equitable. Ashley Gouliard requests summary judgment for her counterclaim.
Así en corto.
That's not how you file a summary judgment, you fucking.
Oh no! No! In terms of legal education, I am the least educated. I am the one least qualified to make comments. I know better than that. You can demand a jury trial or not. That's where you're going with this.
I want summary judgment.
Just like
You're
that.
making a summary judgment. No, they're not. They're going to look at that and go,
All right.
yeah.
I need a second. I'll be
Yep,
back,
okay.
and then I will take your questions.
Actually, she may get summary judgment, and the summary judgment will be you lose.
Yes, the summary judgment will be, look, here's your 72-hour psych hold.
She's gonna get a default judgment.
I can't even.
Iris, I told you this would be fun.
No, you have me eating popcorn very late at night. I'm like on my 4th whiskey. This shit, just no.
You know it's fun.
This is comparative negligence. You owe me like I don't know how much in damages.
Yeah.
I will buy you alcohol when I come visit. But, okay, I promised you guys that I found like the dumbest filing ever. Am I not wrong?
Yeah, very close.
You're
not
getting
wrong.
there. You're not quite there yet.
It's
You
not
guys,
the dumbest. I think that my trial by combat video was a little dumber.
right? But I'm just saying, like, this is what happens when I've got insomnia. I find things like this,
Oh.
and this is why you all love
My
me.
summary judgment.
This is why you all love me.
You know,
Last
I
paragraph
have-
of your complaint or your counterclaim is I want summary judgment.
Now,
My child
no,
wants a puppy,
anything
but that
works.
doesn't mean it's going to happen.
You know,
That's
I know you've
literally not
already
how
issued
anything
a
works.
default, but you can undo that, right?
Hold
Can
on.
you undo the default for me? That's what she wants.
No, she didn't even ask for it.
She didn't request it in her prayer for relief. If you want to bring it back up, she didn't ask for the default to be vacated.
Not only
Nope,
did
It's
she not do
okay.
that, she didn't
They know
actually
what
like.
she means.
But not only did she not request it, she never filed an answer to it. She just filed a counterclaim.
and here's the thing: is that
She did file an answer.
Yes, she
Sort
did.
of. As part of her counterclaim.
Sort of.
Late.
Yes. Well, no, she filed it as answer / counterclaim.
But she did it late after
But
the
she
default
never
had been
requested
entered.
or gave any reason why her default should be vacated.
No, she didn't.
Yes, she did. She said that she was busy helping other people with her psychic abilities and couldn't. She didn't say to not undo the default. She just said that she couldn't answer because of her. She was helping other people.
I don't think that's the way she phrased it. If we
No,
went
she didn't
back
do it right. She just said
Debbie-
that, but she didn't do it
Debbie's got
right.
a question for you, Loki.
She's
Debbie,
communicating
we'll
with them
figure it out.
psychically. It's good.
We'll figure it out, Debbie. I psychically. Mhm.
But I agree with Croco. She went to some attorneys. All of them said no, and she said, "All right, I'll hold my beer. I'll do it."
She should have gone to Brooks. She should have written Daryl Brooks a letter and been like, "Hey, my man, I need
I
an
think
attorney.
Girl,
You
okay.
want to represent me?"
She went to Blandino.
I'm gonna go out on a limb here and say that Daryl Brooks is going, nah, fam. No. You crazy, bitch.
Yeah, I think even
Daryl
Blandino
Brooks
said
is like,
no.
"I'm not touching this."
Like, no.
I mean, there's nothing wrong with the Boxford School of Law.
I think it's better than this school
But
of
it
than
should
a
actually-
psychic school of law.
Well, at least the Boxford School of Law was consistent.
Loki, she went to Brooks, and Brooks said, "What are the grounds?"
Is it lawful?
Make sure-
Are they
Make
practicing
lawful
lawful
law?
law from the bench? Do we have lawful law from the bench? What are the grounds?
He
Did
just
you
told
say
her,
it's an
"Make sure
admiralty
your number
court?
is right."
Is there an eagle on top of that
By
flag?
the
It's
way-
admiralty court.
I want to say something for all of the people watching. When you have a really shit filing like this, asking for summary judgment is not a good idea because that authorizes the judge to file summary judgment against you.
Yes.
Which
And
is,
in fact,
I just. I
In
wanna
fact,
see
that's what I expect to happen here. She put in a demand for summary judgment.
So if nobody asks,
You're
for
right
it,
there
the
at the
judge
end,
can't
this
do
is what you
anything.
go, okay, summary judgment it is. You lose.
Yeah, you can actually file for summary judgment and have the summary judgment ruled against you. That does happen.
And probably fairly often.
Not that often, but
But at least she got some good pictures out of it.
What do they say in show business? Even bad press is good press.
no.
I have a sneaking suspicion that she
Just
is
found the
short-lived
limit of
on
that.
social media right now.
Yeah, her name is pretty much mud because I hadn't actually heard about this one. Objection is speculative. I'm not
You know what?
speculating. If I was that judge, I'd say, yeah, no, fuck that. You want
I have
summary judgment?
insomnia
Cool,
and I
you
find
lose.
these things.
She'll do a follow-up interview with the Pakistan newspaper.
Go over there and let me know how that goes. 'Cause they would be like witchcraft. We're throwing you off a building or burning you alive.
No, in CCW, I mean that sincerely. Like, there is a danger in filing a summary judgment motion
Hey,
because
guys.
they can rule the other way. So you have to be
Sparkling
very
hazard.
careful about that. They can say, you know what, you're right. There is no question of fact. We don't need a trial, but the law is not on your side, so you lose.
Then she's gonna sue the judge.
I kind of want to see that. We should get to all the attorneys.
I have never run into a gramophone record or a gramophone for that matter. Gramophones, those are different, and yeah, we don't go there.
I just like this one.
She'd be better in luck claiming insanity. Pretty sure no.
Not after that. Not after that read. Holy crap!
Look, I mean, it was.
I promised you all fun. You can't say I didn't deliver it.
I'll put it this way: it was at least a filing. It would be like the dumbest student at a low-tier law firm in their first year filing it. But it was a filing.
Guys, I have an idea.
It wasn't technically wrong. It was just legally incompetent.
Wait, guys, I have a brilliant idea. I feel like I should email her and ask her if she wants to come on the channel to explain herself to all of us.
Oh God, do it.
Oh, that's gonna. You think that's gonna? How on earth do you think that is gonna end well?
I don't know
I
that
don't
I
know,
can.
but
I don't know that I can ethically.
You'll know how it ends. She'll know how it ends because she's a psychic.
How does that end well? I have questions.
I don't know that I could ethically be part of that.
you don't have to be part of it, but you know it'd be funny to
I
watch.
will. I will be absolutely in the chat.
That's fine.
I'd
I
watch
will
that.
interview her.
Yep.
The chat can cut up, but I have questions. And I think the only way we're going to get answers.
I have
Like I
sugar.
said, it
Lots
was-
and lots
it
of
was
sugar.
not-
My
was-
first question is going to be, how did you decide when to restart your numbering?
all right, you can stop making fun of me on that one, but
No, I'm making fun of her, but that shit is hilarious because literally, that's the way you're supposed to. You're supposed to number it right. You're supposed to argue the right citations, the right legal arguments, just everything, and it's just that dumb that she
Comments-
doesn't get the numbers right.
I mean, even from like just, and again, we're talking. I guess you're a paralegal, right?
Yep.
Yeah.
Okay.
So even something as simple as commas are not an excuse to reparagraph a statement if you're trying to actually be understood.
No, you have to number things right, space them right, have the exact, like, just even your signature. You know, everything has to be there. They will not even accept it. If you don't even have like your email, your phone number, your address, your everything that you need on there.
Well, and I
Phone
think
number. So the way she has it done like that, the judge would look at it and just be like, nope.
I don't necessarily know that that's true because they give a lot of leeway when it comes to formalities to pro se filers.
Hold on.
Well, yeah,
Link,
but
Link, I spent 16 years in EMS and public safety. Trust me, I can engage that level of crazy with no problem.
I spent several years as, working as a nurse, as a nursing assistant. You know, for psych. I know how this. I know how all of this. I know some of how this works too. It's this lady wants me to reach through this microphone, find her TikTok, and just grab her by the face and shake real good.
no, I
And-
don't think she's crazy. I don't. I just think that she thinks she's right. It's just crazy.
But that's what makes her crazy.
Hush, J. Michael. You would be there right next to me. I don't want to hear it. You know when we have psych rotations, I want to hear of it.
No, I mean, again, to people who don't know, my fiance's a psychiatrist, and she did ER psych for about a year and change.
I condone.
And it's an interesting circumstance.
It's more fun when you're locked in the back of an ambulance with them for like a 2-hour transport to a psych facility that has a bed. You get to amuse yourself with them, just asking stupid questions.
Yeah, fair point.
Mhm.
But yeah, I think look, I'll put it this way. Aside from not necessarily fulfilling some of the federal rules of filing, she presented at least a generally intelligible claim. This is the problem that I always had when it came to pro se filers. Was you have to basically do double duty because judges tend to have a lot of leniency toward pro se filers. So, you know, I've told the story before, but when it was just after my first year of law school, I was working in Philadelphia, and I had a case where somebody allegedly burned down his own strip club and, you know, filed suit when the insurance company wouldn't pay him. And one of his lines was he cited Star Wars. He cited one of his lines was, "Now I feel like what it is to be Jesus on the cross." All right, so this is some of what you get. And the problem that you have is you have to translate their motion or their complaint into actually legal theories so that you can rebut them. So you kind of have to do the work twice. And it becomes very frustrating at times. And this guy, it was like 30 pages of rambling nonsense. But I have to translate each of his arguments into something that I can actually respond to. And that's kind of a skill you just have to learn. And this was 26 pages of rambling nonsense that I would have to try and do my best to convert their arguments into something that is intelligible so that I can respond to it, because judges are extraordinarily lenient when it comes to pro se litigants.
So like right now I have a case and pro se, and you know how when you release a case because of the client, they release you, they write something and you're like, okay, I'm gonna keep the interest, the retain interest in it, right? Because we did everything. It was almost gonna settle. And he
Sure.
goes, no, I don't want you, I want another attorney. That's fine, you have that right. However, we will retain interest in it. He files suit pro se, and it just like, oh, well, you didn't do what you promised. I have to translate that into you broke the contract.
Correct.
So that's what we're defending against now.
Right, and
that's what we're doing. So yeah, you have to work twice, and then he's like, I want discovery. I was like, bro, okay. So I mean, that's what I'm working with right now. So I completely get that. It's just, and we know that the judge is gonna give leeway, but at the same time, it's just baseless. So
well, and that's one of the things that actually frustrates me when it comes to the pro se litigants is I don't think that they should be given that much leeway. I mean, particularly when they're on the plaintiff side. I've always been on the defense. So I think that you should have a certain degree of competence if you are going to represent yourself as a plaintiff, as opposed to hire competent counsel.
Guys,
I don't see why you should be given
I have a treat for
that
you.
much consideration.
Oh, I heard magic words.
All right, we gotta go.
I got a treat for you.
Oh dear.
All right. Why does that sound like a threat?
Probably it might be. Oh dear.
Uh-oh.
This is a good question, especially since you're out of state or out of the country. But if you look at the comments, it's a lot of people who don't even understand the very basics, which is why lawyers are needed. So yeah, the suit is a federal suit based on us being citizens of different states. Whatever state you live in, they have jurisdiction over you as it pertains to the laws that you are to follow. But when it's a lawsuit with people from different states, technically the lawsuit is supposed to be filed in the person that's being sued state. This is a federal lawsuit. It still applies. In the District of Idaho, it's basically federal courts have districts. So like in Houston or in Texas, there's a Southern District of Texas. There's a Northern District, Eastern District, whatever. Depending on what county you live in and where you live, that is the federal court that is supposed to have jurisdiction and local rules that apply to you as well.
Hold on.
It's not totally wrong.
So when a case is filed in the wrong venue, you can file a motion to dismiss and have the case dismissed without filing an answer. But the reason why I didn't do that is because I was being defamed across the entire freaking United States of America and the world on the news media, and they were spreading misinformation, defamatory information about me. So I wanted to file an answer. I felt that it was an opportunity for me to present my case and the actions and claims that I had that were done against me by Rebecca Schofield and her attorneys. Additionally, it was an opportunity to what I felt explain why I said the things that I said regarding the murder of the 4 University of Idaho students and to help them get the evidence they need to back up the things that I was saying. So if I would have filed a motion to dismiss, it would have just been dismissed without hearing my testimony, without hearing what I had to say regarding any of it.
You haven't.
So I'm trying my best not to judge the people in the comments giving out misinformation like this, because I literally had to read U.S. Code, read federal rules of civil procedure, etc., law firms and advice and articles so that I can understand. But it really didn't take much for me to understand this portion. I am not refuting the jurisdiction, which is a federal court. And
Oh my God!
Which means that people from 2 different states, the federal courts will hear it, and they claim the amount is over $75,000 in damages, but I don't know about that, but I still didn't refute that. What I did refute was the other portion of that, which is venue. Even if it's in a federal court, you're typically supposed to sue the person that you want to sue in their jurisdiction, in their district, in their county where the laws apply to them. And it's defendant-based or event-based. It's really not hard to understand.
Pause.
Yeah, John, it's not hard to understand, John.
No,
Yeah.
I mean, venue
Yeah.
honestly is when it comes to the rules of procedure, venue is probably the most complicated topic that any law student or any lawyer can try and discuss.
Okay. Because in this case, all of the initial damage was done in Idaho. Okay, that's where your victim is. Yeah, I would think that then you would go there.
So the argument would be for this to be in Idaho.
There you guys go.
That is where the relevant witnesses are. It's where the defendant resides. That's where the depository of records are most easily attained. The only argument you could possibly make, I don't even think it works, would be that there is some depository of records in Texas that it would be difficult to transmit. I mean, the whole point of venue would be, I don't know, let's take the example of, I don't know, somebody from Connecticut is driving to New York and gets hit in Westchester from a car accident. And they sue in Connecticut and they argue that it's not good venue or the defendant argues that we should change venue because the accident occurred in New York. All the records of the police incidents are from the local police departments. And my client lives in New York. And so it would be a convenience for the witnesses and my clients. That's how you argue venue. I don't understand her argument when it comes to defamation. Venue is almost a non-issue because almost by definition, when we have this internet connected social media state, it's really hard to argue that anywhere is not a proper venue.
Okay.
If that makes sense. And if there are questions, I'm happy to answer them. But venue is not a simple concept.
Okay.
Particularly in our modern world.
Well, and on top of that, how hard is it going to be to transmit information from one place to another when all of the information in question is actually sitting around on the internet?
Not.
It's not. Running off to the topic for a second. I have another citation that I require. This lady's name actually is in the Book of Life. First, I want evidence that said book exists, and 2, I want evidence that you are anywhere in the vicinity of deserving to be in such a book, if one actually exists.
Hey,
we have to do it in
Croc.
that order, though.
Croc.
What?
The website is ashisgod.com.
Okay, there's another side. That is an absolutely extraordinary claim and will require extremely good evidence.
Venue is in the stars.
No, I'm inclined to think that venue in this case, the venue for the original case would have been in Idaho anyway. Because once
Well,
again,
again,
that's where everything except the defendant is.
the way that it works, and this is a genuine, just kind of like straightforward maxim of law, or axiom, excuse me. Look, you are the master of your complaint. You decide where to bring the case. You decide how to bring the case. You decide what counts you want to argue. And then it's up to the defendants to respond. And if they believe that something like jurisdiction or venue is inappropriate, they can respond with that. But
this lady
that's
didn't do that.
not what happened here.
Like at all. I love it. She cites the one case where they're not allowed to like dump the case off as frivolous if they're not just because you're talking about somebody.
But the case is if you are filing in form of pauperis, which I don't
Makes
think
this really
is
hard to do.
here.
What?
Okay. But then at the very end, the last thing she has to say before her signature is, I want summary judgment.
Okay. We'll give it to you.
Against you.
Yes. Yep. Okay. Summary judgment. Summary judgment says that this doesn't make any goddamn sense.
Summary judgment to the plaintiff.
Yeah, summary judgment for the plaintiff.
But even then, the point might even be moot because she's already defaulted. So it's like
it could be just misrepresented.
Well, and that was the other aspect of it, is that she, in her prayer for relief, she didn't ask for the default to be lifted. I don't know if anyone else caught that.
No, I saw it. I've seen people go and beg even to federal courts. Oh shit, I missed it. Please, Your Honor, show mercy.
You don't get 2 bites at that.
Loki, did you see the order for default judgment? Aren't they asking for over $1 million?
Yeah.
Well over.
Yeah, so I mean that's going to be signed.
So
congratulations, she would be entitled to treble damages. So everything that every bit of damage she could prove that could be awarded the thing, she would get triple.
I don't know if there's treble damages on that claim. I was not here when you were doing the complaints, but I don't.
No,
I don't know if it was. I don't know if treble damages were questioned.
No, they didn't ask for treble damages. They would have put that in there. No, but even
I don't know if you'd see.
They could ask for $1 million or more, whatever. But she's basically judgment proof. I don't think she has any money. I think the main point here is to make a point, have her take down her videos, like make her do that, and like have her shut up if she can. But
that could work for a settlement. You shut the fuck up. Keep my name out your mouth.
I mean, either do that in a settlement, or alternatively, have a judge order it.
yeah, I think I want to see the order for default judgment because that should be part of the order.
Hold on. Let me pull it up.
That's something that that's the only real thing that they're gonna get out of her, for her to shut up and take down those videos.
Okay. Just for a moment and not for nothing. Some old dude, Saad. Thank you very much for the incredibly generous donation. That actually would make up most of the cost of the camera I'm looking at. I said nearly all of it. So greatly appreciated. We will make sure it goes. We will make sure it goes to. We will make sure it goes to the appropriate home. Because it will try and
Thank
put
you,
pressure-
Sod.
Wait 1 second. Here we go. It's gonna be that one. Where'd it go?
Lord Smith. What? What? I am nice. I don't do smithing.
Hmm?
Careful, Mean John. I bite.
Do the little squirrels, they don't allow you to do that? I don't know.
Huh?
I don't know if squirrels have opposable thumbs for that.
Actually, yeah. Squirrels are actually capable of grabbing things
So it's
and holding onto them.
it's a personal choice not to do the smithing.
Yeah, unfortunately, little bitty squirrel arms, little bitty forward limbs on squirrels. Yeah, they don't work quite as well for like swinging big heavy hammers.
Big old hammer, itty bitty hands.
Hold on.
Yeah, that would be like
Dragon. She needs to have 1,000 subs. So make sure you subscribe, share, take your friends' phones, subscribe them.
Yes, if I'm not monetized yet, if you would like to super chat me, I have PayPal and Venmo currently until you guys get me to the 1,000 subs.
We're gonna get
But-
you there.
I know, I'm just saying. Someone asked.
We're
But here
whittling
you
away
go.
at it.
Okay.
And I have a present for you, Loki, in a minute.
Okay, hold on.
And Federal Rules Civil Procedure 55A.
That's fine.
David or otherwise from records in the above entitled action that summons a complaint have been served upon defendant named below. It further appears the defendant has failed to plead or otherwise defend in said action as directed in said summons. As provided in the Federal Rules Civil Procedure, the defendant is therefore in default.
Hold on. I'll pull the other thing up for you.
Okay.
As a matter of law, that's correct.
Yeah.
So, I mean, what was that?
Okay, where is this? Motion for the default.
No, the order.
Yeah, no, this is what you need. Hold on. You'll see why. Okay.
Pursuant to Federal Rule of Civil Procedure 55A, Plaintiff Rebecca Schofield moves for a clerk's entry of a default against defendant Ashley Giard. Plaintiff filed her complaint seeking affirmative relief on December 21st, 2022. Docket 1. On December 27th, defendant was served with complaint, summons, and civil cover sheet in this matter. Docket 3. Defendant's deadline to file a responsive pleading was January 17th, 2023, Federal Rules Civil Procedure 12A1A1. To date, defendant has not filed a responsive pleading or otherwise appeared in this matter. The clerk should enter default because plaintiff seeks affirmative relief in her complaint. Defendant has been served, and defendant has failed to file a responsive pleading or otherwise defend the claims made against her. The clerk's entry of default is thus mandatory under Federal Rule of Civil Procedure 55A, which provides that when a party against whom a judgment or affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. Actually, I really appreciate them adding the text of the citation. That's really good lawyering. Following the clerk's entry of default.
It just says it was done.
Yeah, I know. Okay, same shit.
Yeah, but for anybody. There you go. Free court listener with the entire thing and all the documents.
Woohoo!
There you go. But yeah, I mean, look, at the end of the day, a default judgment is not necessarily fatal to the person who defaulted. You just need to show good cause for why you failed to respond in a timely manner. And she didn't do that in what I was here for us to read. So unless I'm missing something, I think the default stands because they didn't even request the relief from the default.
Yeah.
I mean, unless I missed
Well,
something.
she filed docket number 7, defendant's motion for relief from a judgment or order pursuant to FRCP 60 by defendant Ashley Gouliard.
Do you want me to pull it up?
Yeah, please do.
Okay, I'm doing it right
That'll
now.
make it easier for me to.
Yeah, let me pull it up.
Because I was surprised that she didn't ask for relief from default in that particular motion.
In 7, she requested motion for relief from
Here.
judgment. In 9, they responded. In 10 is the default judgment.
There's
Right.
this one.
So now before the court, granting relief from default and judgment pursuant. Do we have the attached memorandum?
Hold on.
There you go.
All right. That.
Where she's requesting relief from the default judgment.
Okay. So Ashley Yard's motion to reopen the matter, granting a relief from default, 60B.
Go down.
Oh my God. I just read the one sentence.
It's basically she just saying, hey, I have enough time to request the court to rethink this.
But I just like it was fraud and misconduct by the opposing party.
Yeah, I just saw that. Excusable neglect and fraud or misconduct by opposing parties. Generally speaking,
You're the one that didn't answer.
but here's the thing, is both of those are valid grounds for reopening a default. Generally speaking, unless you have proof of the fraud or misconduct,
Which is in number 2, facts.
you'd prefer to just do excusable neglect. Did not timely due to being overwhelmed with multiple civil actions and responsibilities.
Multiple.
Okay.
Oops.
During that time, already civil action pending in the county civil court. Represented herself pro se, solely conducted research, solely gathered evidence, and
She made mistakes.
solid prepared for both trials. And let's not ignore that. In that process, she made mistakes while learning how to prepare the answer, counterclaims, and motions. After nearly 40 pages of an answer and counterclaim,
Oh, she
had
really
to
is going to pull
redo
this
it
one out?
correctly. Wait,
Really going to try this
she
statement?
had to do this? She already did this twice?
But wait, keep going.
Overwhelmed with family obligations, custodial parent responsible for physically caring for the child, where it's at, it's on military orders. Fine. Yard is the local next of kin for family member who's in the. Fuck you. I don't care.
I was like, I'm going to pull the military card. What? Oh, wait. She was scared because the Houston Police Department. What?
Yeah. Fraud is grounds for relief from final judgment. Order of proceedings if granted by the court. 60B3, which basically just says that the court can reopen a case that was closed on default if good cause is shown. Attorney and Schofield made false statements in a press release that were just, you're just restating the facts of your claim. Intent to humiliate, harass, etc. I don't care.
I like this one. I didn't know I was in default.
January 19th, 2023, Attorney Olson filed a motion for entry of default on behalf of the plaintiff, requesting responses from defendant due by February 9th, 2023. Attorney Olson did not serve Ashley with a copy of this motion. That's not true. They have an affidavit of service. Okay. Ashley does not have a copy of this motion, is unaware of the contents of this motion. Ashley was made aware of this motion by a staff member of the court in a phone call she made to the court on February 10th. Bullshit. You had until the 9th to respond, but you didn't know about it. So why the fuck are you calling the court on a motion that you didn't know about until the day after you had to respond? Come on. Does anyone buy this?
Keep reading.
I
No.
wouldn't buy anything from her.
Ashley battles with combat-related PTSD, which limits her ability to work and finish tasks when she's under an increased amount of stress. Her stress increased due to the increased amount of responsibility, being defamed in nationwide news media. Yeah, but you have no problem making TikToks. I've noticed that you're able to accomplish that task. If you want to talk about people who have stress and anxiety and don't necessarily want to be in front of a camera, talk to me. Evidence for docket number, I'm not going to read out the numbers, was submitted too late. Ashley had to cease support for her family in the hospital. Her son's birthday celebration was postponed. I don't care.
We got to bring the birthday in.
And her response to civil action is late. Going forward, Ashley will prioritize court rules, orders, and actions and file timely actions. That's not bad. That's okay. Oh. You don't
She needed a thesaurus to find another word.
You don't file timely actions. You file timely pleadings or responses or motions.
Or rebuttals. She's doing the best she can. She's under a lot of stress.
For these reasons, Ashley respectfully requests, you idiot, that the court grant this motion and the relief requested. Thank you. Relieve the entry.
Yes, we know it shouldn't be a semicolon.
Relieve the entry of default and allow defendants to defend, motion, and plead the action. Answer would have been a better term.
Excuse me.
I'm struggling because this isn't an issue of lawyering. This is an issue of basic English. Again, you said you're a paralegal. If that document showed up on your boss's desk, how do you think he or she would respond?
He would laugh.
Quite a lot.
No, you just argue it that she just missed the time frame. There's no excuse, and that's it. Default has already been held because
That's all you have to do.
The order was signed 10 days after the deadline, so they gave her the time frame that she needed.
Well, and that's the thing is, so her deadline was the 9th. She calls the court on the 10th, but she doesn't know about this whole thing. They tell her, you still have 9 days before they actually sign the order. So they're giving you room. They're giving you a grace that you don't deserve, and you still screw it up.
The order, Loki, is 10-1. if you go to number docket, that's where they put the $1 million in. 1.863304.
Yikes.
That's their response to her thing. They're asking for that. Look, she had the time. She still made TikToks after the cease and desist letters.
Oh,
While the lawsuit was moving forward, after her default, after her answer, she still kept making TikToks, and she's still doing it. I'm trying to see if they're asking for the court to make her stop. They're just asking for the money.
Apparently, they've gotten the impression that she actually has that kind of money.
No, the number is basically irrelevant. They know that they're not going to collect that.
Well, it
They're
depends
just
on how much-
claiming they're just claiming that is the reputational damage that was sustained by their client.
It's a symbolic number.
Yeah, it's
symbolic
purely symbolic.
Symbolic or not, though, for what I'm hearing over there is that she got a horrifying number of views. She might actually have it, or be in a position to put her hands on it.
Well, you don't necessarily know. So
we don't know how much she's going to make off of those TikToks.
But I genuinely don't. She might make a lot of money off of those TikToks.
Because I know some people that like they make the kind of money that would make everybody here blush.
TikTok actually is one of the lowest paying per view, post, all of that.
You know,
Compared to
Loki,
everything
I love
else.
you to death, but do you know what YouTube pays me outside of super chats and my memberships?
No, I do know that. I'm just saying, but TikTok's even worse.
And by the way, if you're interested, please check out J. Robine Law. We do gavel to gavel coverage of shows and of trials, and we also have some more fun shows in the back catalog. So please go check it out if you haven't already. Sorry, I had to do a quick plug.
Nope, you're good. You're allowed to. Well, guys, it's 11:20. John, do you want your last cigarette? Let's go with any last questions, and then I will see you guys tomorrow for another stream.
All right. Would you like me to introduce it?
You may, if you'd like.
All right. So this is a staple on my channel. If you stick around to the end, we always have one last smoke for the night. So anything that you ask that is within our ability to answer and within reasonably good taste, we will do our best to do so. So if there are any further questions, Loki, I open it to you.
Link, I had something called a PAO where they break your hip and put in like 8 screws, so I feel your pain.
Any of the people on the panel have a question for me?
No, I'm good for right now.
I don't have a question for you. I'm just saying, you know, I find epic things.
And by the way, thanks, Croc. That's a great way to produce a show.
What?
You got to at least make something up.
No, I'm for as far as questions for you, I don't actually have any. We've been going over all of those fun things. The one I'm curious about is Iris.
What? What did I do?
What kind of law does your firm work on?
So I've done bankruptcy law, mainly civil, bankruptcy law, litigation in that, corporate law, real estate law. Right now, I've also done PI, personal injury stuff as well. I don't like immigration because everybody lies, or criminal. They're probably guilty. So I'll stick to civil.
Right. So you're avoiding the bits of practice which would generally involve people lying their asses off to you just to try and see if you can't save their asses.
It's kind of like I tell my clients, look, tell me the good, the bad, and the ugly, but tell me the truth. I'll know how to put that in front of a judge. And we'll work with what we have. But there's just some clients that just don't believe you, and they get caught out, and they're like, then they're mad, and we're like, look, you didn't tell me this, so how could I help you? It just goes with that.
By the way, I did not say this when I first came on, but it's very nice to meet you, Iris. My background is medical
Okay, Iris, do you just hang out in the
malpractice,
chat, or
and
do you have a YouTube channel?
Oh, no. This was forced upon me by Loki.
I did not force you. I just asked repeatedly until you agreed.
And I was
What
drunk last
Iris
night,
is
so I was
saying,
like, okay.
Iris
Oh,
was
we had
voluntold to be here.
Yes.
But it was fun, and we love having Iris.
no, it was a pleasure. Absolutely.
And Lady Sky is wandering off. Good night.
Well, I am going to also have an early morning thing to do,
All right.
so that we
cheers.
can stream later. So
Good night, you
I
guys.
am going
Nice
to
to meet you,
everybody
John,
say
and
good
everybody.
night. Thank you guys for all sticking through. Love you all. Love my beasties. Be safe. Bye, guys.
Good night, everybody.